Which court? About him. Yes, which court? We have not seen you for a long time now. ಆಯ್ತು ಕೊಡಿ ಕೊಡಿ ಬಟ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇನ್ ಮೇಲೆ ಸ್ವಲ್ಪ ಕಷ್ಟ ತಗೊಳ್ಳೋದು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮಾಡಿ ಯು ಕ್ಯಾನ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ದ ಆರ್ಡರ್ ಇಸ್ ದಟ್ ಸ್ಟೇ ಏನಾದ್ರೂ ಇದೆ ಇಲ್ಲಿ ವೈಫ್ ಕರೆಕ್ಟ್ ಇಸ್ ದೇರ್ ಎನಿ ಸ್ಟೇ ಹಿಯರ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೋಬಹುದಲ್ಲ ಅದಕ್ಕೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಯಾಕೆ ಆಗ್ಬೇಕು Convenient date is now after vacation only. ತಗೊಂಡು ಕಳಿಸ್ಕೊಡಿ ಯಾವ್ದಾದ್ರು ಫಸ್ಟ್ ಇನ್ನೊಂದು ಕೋರ್ಟಿಂಗ್ ಹೇಳಿ ಕಳಿಸ್ಬಿಡಿ ಯಾರಿಗೆ ನಂಬರ್ 3 12th ಅಂತ ಹೇಳಿದಾರಂತ ಅವರು 13 both matters are on 13th before the same court. One and two both.
Number 1, action is page 1, number 1 and 2. Page 2, number 3 to 6. Page 3, number 7 and 8. Page 8, number 9 and 10. Page 9, number 11, 20. Page 10, number 21 to 29.
Then keep. Sir, for the appellate. This is for final hearing or admission? Admission. Who is for the other side? ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ ಅವ್ರು ಬಂದು ಆಮೇಲೆ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ ವಿಲ್ ಅಡ್ಜರ್ನ್ ಇಟ್ ಬಟ್ ಫಸ್ಟ್ ಇನ್ಫಾರ್ಮ್ ಹಿಮ್ ಅಂಡ್ ಗೆಟ್ ಹಿಮ್ ಇಟ್ ಇಸ್ ಓನ್ಲಿ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಇನ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲ ಏನಲ್ಲ there are 3 matters we will not adjourn in the absence of the other side. This next
number 30 to 33. Number 2, page 1, number 1 and 2. Page 2, number 3 and 4. Page 3, number 5 to 7.
whatever we say to the previous case with discrimination ಮಾಡಂಗಾಗುತ್ತಲ್ಲ ಇವ್ರೆ Object will take the responsibility. Response council. Yes. Will not take up any matter now. This final hearing in the one hour next week. Yes.
Page 4. Page 5, number 8. Yes.
Yeah, filed it. Yours is Reliance. The other vehicle was? That is respond number 3. Insured by respond number 3. File ಮಾಡಿದೀವಿ ಅಂತಾರಲ್ಲ ಮೆಮೊ ಅವರು ಚೆಕ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ ಅಂದಿದ್ರು ಅವರು ಪಾಸ್ಪೋರ್ಟ್ ಇಂಡಸ್ಟ್ರಿ but liability is against both of you or only against you? ಅವರು ಅಪೀಲ್ ಹಾಕಿದಾರಾ? Permission who is sir? You are insured. In their appeal. ಈ ಕೇಸಲ್ಲ ಅಲ್ಲ. ಈ third unrepresented. ಎಲ್ಲಿದೆ ಅವ್ರ ಮೆಮೊ ಇಟ್ಟಿರ್ತಾರೆ? No such person in the address notice issued. Steps to be taken in respect of R2. Also. But you are. ಏನು ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ, ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದೀರಿ ಅಂತ ಏನು ಮೆನ್ಷನ್ ಕಾಣ್ತಾ ಇಲ್ಲ. You gave it in the open court. ಇನ್ನೂ ಕುಡಿಬೇಕು ಅಂದ್ರೆ ನಾಟ್ ಹೋಗ್ತಾನೆ ನಿಮ್ಗೆ ಮಿಸ್ಲೇನಿಯಸ್ ಪೇಪರ್ ಅಲ್ಲಿ ಏನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಟೋಟಲ್ ಕೊಟ್ಟೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೊಟ್ಟಿದ್ದೆ ಅಂತ ಬರ್ತಾರೆ. ವಾಪಸ್ ರಿಟರ್ನ್ ಮಾಡಿದೀವಿ ಅಂತ ಕೊಟ್ಬಿಡಿ. ನಾನು ಕಷ್ಟದ ಸಬ್ಮಿಟ್ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2. Respond number 2 is the insured under respond number 3. Respond number 3. You are on which point? You have negligence. The ಎರಡು ವೆಹಿಕಲ್ ಡ್ಯಾಶ್ ಆಗಿ ಥರ್ಡ್ ಬೆಳೀತು. Victim was in the third vehicle. So ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ನೆಗ್ಲಿಜೆನ್ಸ್? Charge sheet was filed against whom? Since the appellant has no claim against respond number 2, this respond number 2 is dispensed with as paid for. ಇದರಲ್ಲಿ ಏನು ಟೋಟಲ್ ಮೂಡ್ ಅಂತಿದೆ, ಒಂದು ಸ್ಟೇ ಇದೆಯಾ? ಯಾವ ಮೂಡ್ ಮ್ಯಾಟರ್? Correct. What is it? You have received any amount or not? Total claim was 50,52,000. ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲಲ್ಲ ಇನ್ನು. ರೆಕಾರ್ಡ್ಸ್ ಯಾವ್ದ್ರಲ್ಲಾದ್ರೂ ಬಂದಿದೆಯಾ? ಬಂದಿದೆ. TCR ಕಾಮನ್ TCR ಅಡ್ಮಿಟ್ ಲಿಸ್ಟ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಇಂದ ಆಯ್ತು ತಗೊಳ್ಳೋ ಫೈನಲ್ ಹಿಯರಿಂಗ್. ಇದರಲ್ಲಿ ಪರ್ಮಿಷನ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ ದ Regional Office Staff Memorandum 13/8/2018 and 1/2022. These applications have to be heard along with the main matter. No? You have filed any objections to that? You have filed it. Advocate for the appellant. On the advocate on the concept. Here, your appeal, Chetan. There are applications in your appeal. Both applications are filed by you only. I have one of 2021 and one of 2022. The applications are reducing the additional evidence. They shall be heard along with the main matter. ಯಾರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ವಾಗುತ್ತೆ? ಆಮೇಲೆ 1.1 1.2 ಎರಡು ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳಿ. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಈಸ್ ಆಲ್ರೆಡಿ ಅಡ್ಮಿಟೆಡ್. Admit List for final hearing on. ಆಗೋದಿಲ್ಲ ರೀ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಸ್ತೀನಿ ಪಾಠ ಇರೋದಿಲ್ಲ ಮುಗಿಸ್ಬೇಕಲ್ಲ 18th. Producing document filed by the advocate of the respondent. Document produce ಮಾಡೋದಕ್ಕೆ ಮೆಮೋನ MC. Death certificate. Rukini AM. That is Rukini AM. She is not a party, no? Name of the mother. Birth certificate. Respondent. Respondent has produced, filed it. Not death certificate, birth certificate. No representation for the respondent. Who represents R. Harinath. Notice the advocate for respondent ಅಂತ ಇದೆ ಅವರ ಹೆಸರು ಬೋಲ್ಡ್ ಮಾಡಿ ತೋರಿಸಿಲ್ಲ ಅಲ್ಲಿ. Who has moved it? Kotal moved ಅಂತ ಇದೆ ಅಲ್ಲ. The petition is dismissed. In urgency. No representative. Though the respondent's counsel has moved the matter, he is not present. Learned counsel for the appellant submits the copy of memo. But ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೇಸ್ ಮಾಡಿಲ್ವಲ್ಲ ಮೆಮೊ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ. The signature is receiving clerk. Submits that the copy of memo is not served on him. The response counsel can do the needful in 2 weeks. ಹೇಳಿದ್ವಲ್ಲ shall do the needful ಅಂತ. R2 is dead and respondent number 2. 1 second. Respondent Lakshmi Ragraj. Claim petition related to whose death or injury? Yashwant. They were the parents of the deceased. He is not survived by any other parties. They have filed a memo here. Non-filing of memo with order dated. You are filing memo. Second sector. ಅಲ್ಲೇ ಕೊಡಿ ರಿಜಿಸ್ಟ್ರಿನಲ್ಲಿ ಅವರೇ ಎಲ್ಲ ಚೆಕ್ ಮಾಡ್ತಾರೆ. ಸೆಕೆಂಡ್ 3 and 3.1 ಅಲ್ಲಿ ಇಲ್ಲಿ ಕೊಡ್ತಾರೆ. ಅದಾದ್ಮೇಲೆ ಅಲ್ಲಿಂದ ಫೈಲ್ ಅಲ್ಲಿ ಹೋಗೋದ್ರಲ್ಲಿ ಎಲ್ಲರೂ ಕಳೆದೋಗುತ್ತೆ.
My lord, I am for the appellant, my lord.
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಕೊಡ್ತಾರೆ. ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. Dismissal of the appeal for a non.
But I am filing an application for recall the order, my lord. That I am doing.
Where is the application?
R6 the one. Yeah, today I am going to file it. Today I am going to file it. Today I am going to file it. Along with the steps, I am going to file an application.
R6. Already discussed no further orders are required. IA2 of 2023 for withdrawal of amount. Another ಎರಡು application for withdrawal.
One is by wife and children, another is by the parents, my lord.
R4. Okay, why they have any conflicting interest? ಎಲ್ಲರೂ ಒಂದೊಂದು application ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ? R1, 4, 5. Why all of you have filed this? Advocates there in R1, 2, 3 are minors. 4 and 5 case Nagaraj.
Parents.
What do you say for release of the amount?
My lord, in fact, we have disputed the negligence. 25% of the compensation may be permitted to withdraw, subject to result of the appeal. Because we have disputed the liability also. Minor was riding the motorcycle. He committed an accident. Admittedly, he's a minor.
Produce 1 crore 17 lakh 60,000 180.
25% may be permitted to withdraw, subject to result of the appeal. Balance amount may be kept in any nationalized bank until
How much they have deposited? Ili deposit ಮಾಡಿದ್ದಕ್ಕೆ
72 lakh we have deposited.
Produce because office
72 lakh.
deposit ಮಾಡಿದಾರಾ?
ಆಗಿದೆ. I'll produce the acknowledgement also, my lord. It is here. I am going to produce it today.
Now, counsel for respond number 1 to 5. 1 to 5 subject that the appellant has deposited the amount. Therefore, office objection in that regard stood complied. And what was he? What was he? This is
My lord,
engineer. You are disputed liability.
liability, negligence, and also quantum of compensation also. my
Where
lord.
have you produced this? You said DL expect produce ಮಾಡಿದಾರಂತಲ್ಲ.
ಇಲ್ಲ, my lord, I think it is not pertains to him. Your last may kindly see, as per the charge sheet, he is only 17-year-old. But that DL produced by, that DL produced by somebody else. He is not
Trial
from.
court ಅಲ್ಲಿ are not taken up all these contentions ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
That is why we have challenged
Who is this RW1 Ibrahim Mujawar?
our insurance company officer. We have examined too. Even we have examined the RTO also. Totally five witnesses we have examined.
Correct. ಇಲ್ಲ RW1 Mujawar ಅಂತ ಇದೆ, ನಿಮ್ ಸ್ಟಾಫ್ ಅಂತ ಹೇಳಿದ್ರಿ. There is no other witness except RW1.
ಜ್ಯೋತಿ ಅಂತಿದ್ದಾರೆ. ಜ್ಯೋತಿ PW RW3 ಜ್ಯೋತಿ.
RW3 ನಾ ತೋರಿಸಿಲ್ವಲ್ಲ ಇದರಲ್ಲಿ?
ಸಾರಿ, ಒಂದ್ ನಿಮಿಷ. RW one minute. There are totally Ibrahim Mujawar. Sorry.
Number 2 examined RW.
RW1 only. Sorry.
Correct statements ಎಲ್ಲ ಮಾಡ್ತಿರಲ್ರಿ?
ಅಲ್ಲ ಸರ್, ಬೇರೆ ಕೇಸ್ ಕನ್ಫ್ಯೂಸ್ ಆಯ್ತು. ಸಾರಿ.
So I have not examined the RTO. They have produced records ಬಂದಿದೆಯಾ? ನೋಡಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಯಾರ ಮೇಲೆ ಹಾಕಿದ್ರು ನೋಡೋಣ. ಚಾರ್ಜ್
ಶೀಟ್ both the owner and also rider ಇಬ್ಬರ ಮೇಲೆ, because he owner has allowed a minor to ride the motorcycle.
One second, we'll see.
Kindly see the accused number 1, my lord.
Charge sheet is exhibit. Exhibit P8 ಅಂತ. P8 ಅಂತ ಇದೆಲ್ಲ charge sheet. 46 is real.
My lord, accused number 1 is Narsimurthy, 17 years. On the right side it is mentioned 17 years. Second page, my lord. Column 12. Column number 12. Column number 12. Seventeen years.
Is 8/10/2016.
Yes, my lord. 17 years. And A2 is, my lord, owner of the motorcycle.
There are 2 motorcycles. Which
yes, my lord. Even the involvement of the vehicle is also in dispute. Your last may kindly see, as per wound certificate, my lord. Kindly see the wound certificate, my lord.
Is it P46?
There is a collusion between 2 owners.
46 ಅಂತ ಹೇಳ್ತಾರೆ, ಅವ್ರ ಲೈಸೆನ್ಸ್ ಇತ್ತು ಅಂತ. Whether that related to that date ಅಂತ. 8/10/2016.
I have informed the insurance company to verify the genuineness.
ಈ ಸ್ಟೇಜ್ ಅಲ್ಲೆಲ್ಲ ಮಾಡೋದಲ್ಲ, ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಮಾಡ್ತಾರೆ.
My lord, regarding liability, even the vehicle involvement is also in dispute. Because in the as per the wound certificate, the deceased was riding the insured vehicle. Subsequently, it is changed. There is a lot of confusion is there. As per wound certificate, you ask me kindly see.
Driving license.
Exhibit P9.
46.
That's why, my lord, a small amount may be released for the time being.
ಸಿಗ್ತಾನೆ ಇಲ್ಲ 43 ಆದ್ಮೇಲೆ ಬೇರೆ ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ This is written India visitor managers Court of India.
P46 ಅಲ್ಲಿ
ಮೊದಲು ಏನಾದ್ರೂ ಸ್ವಿಚ್ ಮಾಡಿದ notarized copy of ID card.
My lord, date of application, my lord, 19. Your lordship got it, my lord.
You have
What is-
exam. Witnesses ಯಾರೋ ಇದ್ದಾರೆ. Driving license 24 years. When it was issued, it was application date
19 July 22. 22.
ಆಗಿರೋದು 8/10/2016 ನಲ್ಲಿ ನಿಮ್ಮ
ಹೌದು,
ಅಪ್ಲಿಕೇಶನ್
22 ನಲ್ಲಿ.
ವಿಜಯ್ ಕುಮಾರ್ ಒಂದ್ ನಿಮಿಷ ಅವ್ರ ಹತ್ರ ಕೇಳ್ತೀವಿ ಎಲ್ಲಾರ್ದನ್ನ ನೀವೇ ಹೇಳ್ಬೇಡಿ.
Please, my lord. Please, my lord.
Issued on 22/7/2016. Then application certified copy of license. 8698. DL issued on 22/7/2016 ಅಂತ ಇದೆಯಲ್ಲ, that is date of application.
Then, my lord, his age is 24 years. That is wrong.
If they have examined
ಅಲ್ಲ, ಇದು ರಾಮನಗರದಲ್ಲಿ ಇಶ್ಯೂ ಆಗಿದೆ. You last me kindly see the address. RTO Ramnagara. But this rider is from Chikbalapura. Chikbalapura. His native was Chikbalapura. DL was issued in Ramnagara. I don't know how can they issue. They cannot issue.
Other document have, what is his address proof they have produced? His address proof they have produced? P8 copy of charge sheet. P8 charge sheet ಅಲ್ಲಿ ಅವ್ರ address ಯಾವ ತೋರಿಸಿದ್ದಾರೆ?
Charge sheet ಅಲ್ಲಿ page number 2. Next page, my lord, column number 12. Column number 12. Chikbalapura. But driving license produced is of Ramnagara.
ಕರೆಕ್ಟ್. ಎಲ್ಲಿ ಜನರಲಿ ಎಲ್ಲಿರ್ತಾರೆ ಅಲ್ಲಿ ಕೊಡ್ತಾರಲ್ವಾ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್.
ಬೇರೆ ಕಡೆ ಕೊಡೋದೇ ಇಲ್ಲ.
25% ಹೇಳ್ತಾರೆ. 25 ರಿಲೀಸ್ ಬಿಕಾಸ್ ಇಟ್ಸ್ ಹ್ಯೂಜ್ ಅಮೌಂಟ್. So many of it.
ಅದು ಕೂಡ ಜಾಸ್ತಿನೇ, ಬಟ್ ಏನಂದ್ರೆ
Orders and I number 2, 3 and 4 of 2022. The appellant's counsel submits that he is disputing the liability of the insurer on the ground that the rider
minor.
So the offending vehicle was being ridden by a minor. The claimant's counsel submit that as per P46, the driving license, the rider was major. The appellant's counsel submit that exhibit P46. But our examine ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಡ್ರೈವರ್. Who is the RTO? RTO is PW. 4 ಜನ ಇದ್ದಾರೆ. PW 1, 2, 3, 4 ಅಂತ. Aged parents ಇದ್ದಾರೆ. Amongst these, who was the RTO? PW4. It's very different.
No, he is not a RTO.
PW4 Kiran Kumar.
He is not an RTO.
He is the employer of this.
No.
This is
ಇಲ್ಲ.
my colleague ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದೌದು. ಇಲ್ಲ, they have not examined any RTO or police officer.
ಇನ್ಕರೆಕ್ಟ್ ಆಗಿರೋದನ್ನೇ ಅವರು ಇದು ಯಾರ ಜನರಲ್ ಮ್ಯಾನೇಜರ್ HR
ಇಲ್ಲ.
PW2 ಯಾರ ಐ ವಿಟ್ನೆಸ್ ಎಂಪ್ಲಾಯಿ
ಐ ವಿಟ್ನೆಸ್ ಅಷ್ಟೇ. They have not examined any.
He is also a colleague, Retail Indian Private Limited. They are not examined that.
Not examined.
Council disputes the genuineness of exhibit P46 on the ground the RTO was not examined. ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲಲ್ಲ.
ಅಲ್ಲ.
R1
ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಲಾಸ್ಟ್ ಮಿನಿಟ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು ಆಫ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪ್ರೊಡ್ಯೂಸ್ ಬೈ ದ ಕ್ಲೈಮೆಂಟ್. ಇಟ್ ಇಸ್ ಬೈ ಓವರ್ಸೈಟ್ ಏನೋ ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗಿದೆ ಅದು. ಓವರ್ಸೈಟ್ ಅದು. Without the knowledge and consent.
RTO was not examined by both the sides under the circumstances incident. The claimants are the widow, minor children, and the aged parents of the deceased. Under the circumstances, it is just to release this 50% of the amount in deposit to the claimant. 50% of the amount in deposit ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ. ನೀವು ಒಬ್ಬರೇ ಮಾತಾಡ್ತಾ ಇರ್ತೀರಾ ವಿಜಯ್ ಕುಮಾರ್, ನಿಮ್ದು ಒನ್ ವೇ. ನೀವು ಈ ಕಡೆಯವ್ರನ್ನ ಕೇಳೋದೇ ಇಲ್ಲ. To some extent, you are causing inconvenience to the court also. Correct? ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ವಲ್ಲ ಅಂದ್ರೆ 50% of the amount in deposit to the claimants in accordance in terms of the awards regarding their share and their shares and investment. ಯಾಕಂದ್ರೆ ಮೈನರ್ ನಿಮಗೆ ಕೊಡೋದಿಲ್ಲ, ಅದು ಇನ್ವೆಸ್ಟ್ ಆಗ್ಬೇಕು ಮೈನರ್ಸ್.
And balance amount may be kept in any nationalized bank. Balance amount may be kept in any nationalized bank. Please, my lord.
Balance amount shall be invested in FD for a period of 1 year. Next
one again, the number 5, PL integrity.
What is that you are filing? Huh. Just heard the copy only. Just want to go through that? You want to go through that? Oh. Hi, ಕೊಡಿ. ಎಲ್ಲದರಲ್ಲೂ ಡಿಲೇನಾ? Delay in everything. See, your advocates on record, they supply it to you in advance. Adre courtige they don't show that courtesy. But the senior cover junior cover junior. Yes. ಕೊಡಿ. ಇಲ್ಲಿ ಒಂದೇ ಸೆಟ್ ಇದೆ. ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಹಾಕಿದ್ರೆ ನಾವು ತಗೊಳ್ಳೋದಿಲ್ಲ. ಅಬ್ಜೆಕ್ಷನ್ ಕೊಡಿ, we'll hear you. What is that application? You can't file the application here. ಅಲ್ಲೇನಾರ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಅವರೇ ಹೇಳ್ತಾರೆ, ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು. What application you are trying to file? For ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಳ್ತೀವಿ. ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಹಾಕಿ ಹೇಳಿ. Who is the defendant? Defendant or respondent? Last time court observed ಮಾಡಿದ್ದಾರೆ. She was 92 when the suit was filed, and even in the appeal also you have shown her age as 92. The court has made observations. Contempt court ಅಲ್ಲಿ. Now she is no more. Then correct. Correct. What are you? ಅವ್ರು ಆದಾಗ ಹಾಕ್ದಾಗ ನೋಡಿದ್ರೆ ಇವ್ರು ಅಯ್ಯದ ರಿಟರ್ನ್ ಕೊಟ್ಬಿಡಿ ಅಂತ. Now we hear you as it is. Yes. Statement of objections to I number 1 of 2020. Yes. Is your application. Yes, Leonard. Even otherwise, it's a Christian will. Why it has to be compulsorily probated? Any probate was produced? ಅಲ್ಲ ಅದರ probate out. Okay. Yes. Correct. Now you, according to you, they are interfering, taking advantage of this interim stay. Now, what is that acts of interference? Where have you mentioned? That contempt type. Next. One is contempt. Second. Correct. Corporation authority is issuing notice to you does not amount to interference by them. There are other interference because this court only said that. Where is that prima facie material to show that they had entered the property? Which paragraph you have said? In which paragraph your application you have said on which date they entered into your property? Para 7. Trial court in really. Now you are not para 7, para 9 it seems. Para 9. Para 7 prior to suit. Para 9 anta karadu. Correct. What is the document you said to have produced that annexure B? Notice to whom? Assistant Executive Engineer. Not to any third person, third parties. Not to the third parties. It is the assistant. No, you have issued to the Assistant Executive Engineer PBM. They are, see, correct. If they are doing anything, your action is something else. But now you say that they are trying to interfere with your possession. What is the material for that?
And then try to return us. Say that here you put a promotion conception there and we take action in devolution. That is what is happening.
Correct. That order was passed on hearing both of you or expert order that interim stay was order sheet. When that interim order was passed, stay. And two. Okay. Correct, but these people also injunction stay stay if there is an executable order. If they file execution for injunction decree, then we could have sought stay. But they should not have taken 1/2/2019. IA 1 of 2014 is application for condonation of delay. Delay of 2 days is condoned. IA 1 of 2013 is for stay. IA 1 of 2013 is allowed stay of judgment. So they had not filed any. The Learned Counsel for caveat respond number 1 and 2 shall have the liberty to file application seeking modification. It is there. Correct. See, we say PBMP, they cannot seek interim stay for PBMP. I mean, the injunction. But against the injunction decree, there cannot be any stay. And liberty is given to you. Liberty is given to them to seek modification of the order. Now your people cannot, in the guise of the stay order, enter the property. You completed your side? You completed your side? No repetition, I tell us. Yes. Not about putting up of the construction. You start simply the stay of judgment and decree. Yes. To seek modification. Along with statement of objection or Court 23. Note this. We got it. 4/12/2020. ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ ಕೊಟ್ಟು ಒಳ್ಳೆ ಕೊಡೋದು ತಿರುಗಿ ಕೊಡೋದು Contempt court order is already there in the record. Notice.
Lots of concepts is there. That's where the BBMP authority, they have given issue to demolition.
Correct. That is between those two. We are not going to pass any order against PBMP authorities. But our concern is that in the guise of a stay order, you should not go there. He is submitting that you are taking some other persons also other than PBMP. We are not going in the guise of this injunction order. They cannot seek any prohibitory order against the BBMP. But you should not feel this temporary injunction vacate, stay order will vacate that. Correct. See, they had the operation. We are not saying. We are saying this injunction order, permanent injunction order. There cannot be any stay for permanent injunction order unless they put that to the execution. Attachment ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಬೇರೆ ಇದನ್ನ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ both side and he is submitting that you are not even produced the yes one clarify one thing. He said you have not even produced the will. Is that correct? Before the trial court you had not even produced the will. That's what he said. Is that correct? Original sale deed, GPA, death certificate, RTC, Andhra Bank passport, notice, right? You have not produced the bill, you rely. Right. No. It's violent. They need not seek declaration. Why should they seek declaration? If you sell it on the basis of a will, you should prove that there was a will. You are a purchaser or a vendor? You are also a purchaser. Correct. Who was the legatee? This defend number 1, VC Mohan was the...
One society was established before according to this and his wife purchased the two different properties. Different properties. Just executed it in favor of our vendor one district. As far as that in 1867, they come back.
In which year? According to will was of the year 1966. Sale deed is
This is 1966.
that is will.
In favor of our vendor one district.
Like
And then
he sold it on 1901-2005. They disputed the will as well as, therefore validity of the sale deed. Now you were submitting that they should have sought declaration regarding sale deed.
According to this, second one
They are also claiming on the will. Why? Why he was also a steward? What is that? Why he executed in favor of Stewards Association? He was a jockey or a Christian character. Why he executed the will in favor of Stewards Association? Was he in this race or? The Stewards Association is not connected to this horse race. Correct. Church though, correct. Affiliated to which church? Probably ಹೀಗಿರ್ಬೇಕು ನೋಡಿ. Stewards Association in India, probably that is related to this horse race. Then on Stewards Association ಇರ್ಬೇಕು, ಅದೇ ಇರ್ಬೇಕು. He might be associated with this horse race. ಆ will ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಬಂದಿಲ್ವಾ? $12,1092. $17,3. Anyway, after execution of that alleged will, he died on 17/3/1993. According to yes, according to you, but according to them, he executed the will on 12/10/1992. With P33. Now you are claiming under the will of that chase or this plaintiff number 2 chase? Your vendor, that is defendant number 1, is claiming under the will of the husband or wife. Wife is alive. Now we will make an observation that this will not come in the way of the BBMP taking any action in accordance with law. But there cannot be a stay for injunction order. Injunction decree, when that too, when it was in operation all along pending the suit. Suit was of the year 2005. It was disposed of in 2013. Is anything else you want? But the liberty was reserved. No, you or anybody claiming through you. ABMP cannot claim through you. Correct. You make an observation that this order will not come in the way of BBMP taking any action if there is any violation in accordance with law. So, that is not, see, you have to sort out that there only. Under the provisions of that Act, Municipal Corporation Act. Submits statement of objections to I number. I number is 1850, 1 of 2023. Person I of 2023. Heard Srimati so-and-so, and senior counsel appearing for advocate on record for the appellate from Shri Vijayarajan, Madam Counsel for responsibility. Which of the defendant has filed this? Only purchaser has filed this appeal. Your vendor has not preferred any appeal. Challenging the judgment in the for declaration of title and current injunction Defendant number 2, invoice number 728 of 2005 has preferred this appeal. This court, the application of the appellant by order dated 2/1/2019, 1/2/2019 stayed. There objection ಹಾಕಿಲ್ಲ ಅಂತ ಇಲ್ಲೇನು ಹರ್ಡ್ ಅಂತಾನೆ ಇಲ್ಲಪ್ಪ ಇದ್ರಲ್ಲಿ orders ಅಲ್ಲಿ whether he had appeared caveat ಅಂತ ಇತ್ತು ಆದ್ರೆ there is no mention. IA1 is, but the order does not say that they were present and they were heard. Till further orders ಅಂತ caveat 1 and 2 ಅವ್ರು ಹೇರ್ ಮಾಡಿದೀವಿ ಅಂತ ಏನು ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. Because in first application, in the order in the first application, it is said no objections by the response counsel ಅಂತ. This court stayed the execution operation ಅಂತ ಏನು ಹೇಳೋದಿಲ್ಲ, ಬರೀ ಸ್ಟೇ ಅಂತ ಹೇಳ್ತಾರೆ. Stayed the judgment in statement as per the informed judgment and decree and further orders. But he was also given to the caveat respondent file application seeking modification of the order. The other application, the response or response 1 and 2 of seeking interim injunction against the appellants or anybody claiming to them on the ground that in the guise of the interim stay, the appellants are trying to interfere with the possession of only respond number 1 ಹಾಕಿದಾರಾ of respond number 1, possession of the suit property by respond number 1. Next paragraph. The records show that in the application it is also contended that taking advantage of the interim stay, the appellant is instigating the BBMP authorities for demolition of the properties on the ground that they were illegal constructions. So there is no dispute that a temporary injunction order was there in the trial court also, because he was submitting. You ಹೇಳ್ಬೇಕಲ್ಲ ನಮ್ಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ. TCR ಆರ್ಡರ್ TCR ಬಂದಿದೆ ಅಲ್ಲ, ಪೇಪರ್ ಬೇಕಲ್ಲೇ ಆರ್ಡರ್ ಶೀಟ್ ಬಂದಿರೋದಿಲ್ಲ. ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಆಗಿ ಬೇರೆ. No, that was after hearing. Or we say you are not repeating that ಅಂತ ಬರ್ಕೊಟ್ಟಿದೆ. ಟ್ರಯಲ್ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲೂ ಇದೆಯಾ? Where do we find that? 320. One second. 320. ಸೂಪರ್. ಎರಡು ಮೊದಲು ಬೇರೆ 2 ಸೂಟ್ ಬರೀ ಬೇರೆ ಇಂಜೆಕ್ಷನ್ ಇರ್ತಾರೆ. ಅದರಲ್ಲಿ 17th March 2005. Yes, there is an order. Easy Mohan against him, your vendor against him there was. There's no dispute that during the time before the trial court, before the trial court, there was an interim injunction order in favor of respond number 1. Correct. ಮುಗಿಸ್ಕೊಂಡು ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಮುಗಿಸ್ಕೊಂಡು. ಸಿ ಸಿಂಪಲ್ ಪ್ರಿನ್ಸಿಪಲ್ ಇದು ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಮೇಲೆ ಎಲ್ಲಿ ಸ್ಟೇ ಬರುತ್ತೆ? ಎಕ್ಸಿಕ್ಯೂಟಿಬಲ್ ಡಿಕ್ರಿ ಇದ್ದಲ್ಲಿ under circumstances it is necessary to protect the possession of respond number 1. Therefore, the appellant or anybody claiming through him are hereby restrained from interfering with the possession and enjoyment of the peaceful possession and enjoyment of the property by respond number 1. However, it is made clear that if there is violation, if there is any violation of building bylaws or building rules, this order does not come in the way of DPMP taking necessary action in accordance with law. Item number 1 of 122 is processed. Regarding ಫೈನಲ್ ಇಯರಿಂಗ್ ಈಗ ಇನ್ನು ಎಷ್ಟು ದಿವಸ ಉಳಿದಿದೆ ಹೇಳಿ ಜನವರಿ ಡೇಟ್ ಬೇಕಂದ್ರೆ ಫಿಕ್ಸ್ ಮಾಡಿ ವಿ ವುಡ್ ಹ್ಯಾವ್ ಟೇಕನ್ ಇಟ್ ಈಗ ನಮ್ 4-5 ರಿಸರ್ವ್ ಮಾಡಿರೋ ಮ್ಯಾಟರ್ ಇದೆ ಅದು ಮಾಡ್ಬೇಕು ನಮಗೆ ಆ ರೀತಿ ಕಂಟಿನ್ಯೂ ಆದ್ರೆ ತಗೊಳ್ತೀವಿ ಅಷ್ಟೇ ಅಲ್ಲಿ ಎಲ್ಲ ಹಾಕೋದ ಕೋಟ ಇದ್ರಲ್ಲಿ ಹಾಕಿದ್ರಿ ಸ್ಕೇಲ್ for final hearing on date. Even you submit that in the office. ನೀವೇನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದಿಯೋ ಅಲ್ಲೇ ಫೈಲ್ ಮಾಡಿ ವೈ ಶುಡ್ ಬಿ ಪಾಸ್ ಓವರ್ ನಾವು ನಿಮ್ಮ ಮೊನ್ನೆ ಇಲ್ಲೇ ಇದಾರಲ್ಲ ಇದರಲ್ಲಿ twice it was rejected. Now only change in circumstance. You have said mother's health. It was made out in the earlier application also. Still it was rejected. Main matter hearing ಮಾಡಿ ಮುಗಿಸ್ಕೊಳ್ಳೋದು ಬಿಟ್ಟು ಅದು ಯಾವುದೋ ಒಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ ಆರ್ಡರ್ ಕಾಪಿನ ಅದಕ್ಕೂ ಈ ಕೇಸ್ಗೆ ಏನು ಸಂಬಂಧ ಇಲ್ಲ. You have produced some order as if the order was passed in this case only, but that has nothing to do with this. Delay will order for expedited hearing ಅಷ್ಟೇನೆ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. We went through that. Of course it was based on circumstantial evidence etc. ಅದರಲ್ಲಿ ಇರ್ಲಿಲ್ಲ and 304 ಬಿಗೆ ಮಾಡಿದ್ದಾರೆ 302 ಅಲ್ಲ ಬಿಡೋಣ ಅದು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ನಮ್ಗೆ ಏನಾರ ಡೈಯಿಂಗ್ ಡಿಕ್ಲರೇಷನ್ ಇತ್ತು ಆ ಲೇಡಿದು ಅಂತ ಅಷ್ಟು ಡೀಟೇಲ್ ಆಗಿ ನಾವು ಓದಕ್ ಹೋಗ್ಲಿಲ್ಲ. ಆಯ್ತು ಮೇನ್ ಮ್ಯಾಟರ್ ಇಸ್ 2018 ಅಫಿಲ್ ಗೆಟ್ ಇಟ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಏನ್ ಮಾಡ್ಬೇಕು IML ಏನ್ ಮಾಡ್ಬೇಕೀಗ ಯು ವಾಂಟ್ ಅಸ್ ಟು ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಆನ್ ಮೆರಿಟ್ ಬಿಕಾಸ್ ಯು ಹ್ಯಾಡ್ ಮೇಡ್ ದ ಗ್ರೌಂಡ್ ಸೇಮ್ ಗ್ರೌಂಡ್ ಮದರ್ಸ್ ಹೆಲ್ತ್ ಗ್ರೌಂಡ್ ಮಾಡಿದ್ರಿ ದಟ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಬೈ ಅನದರ್ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್. ಮೇನ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಸ್ಕೊ 2018 ವೈ ಡಿಡ್ ಯು ನಾಟ್ ಗೆಟ್ ಇಟ್ ಲಿಸ್ಟೆಡ್ ನೋಡಿದ್ವಿ ಅದನ್ನ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ವಿ ಬರ್ಲಿಲ್ಲ 20 ಮಾಡ್ಕೊಂಡು ಪೆಂಡಿಂಗ್ ಯಾಕೆ ಇಡಿಸ್ಕೊಂಡಿದೀರಾ ಅಂತ. ವೆದರ್ ಹೌ ಇಸ್ ದ ಮದರ್ ನಾವು ಅದು ಏನು ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂತದ್ದು ಏನು ಕೊಟ್ಟಿಲ್ಲ ನೀವು ಏನೋ ಒಂದು ಹರ್ ಹೆಮೋಗ್ಲೋಬಿನ್ ಲೆವೆಲ್ ಇಸ್ ಬೆಟರ್ ದನ್ ಅಸ್ ವಿ ಹ್ಯಾವ್ ಸೀನ್ ದಟ್ ರೆಕಾರ್ಡ್. ಬರ್ತಾರೆ ಆರ್ಡರ್ಸ್ ನಂಬರ್ 1 now merely because it is a successive suspension application it has come before us. This is the third order number 1 third court side. This is the third successive application of the appellant seeking suspension of his sentence. His other 2 applications were rejected by this court on 26/4/2018 and they were on bail during the trial. But main matter ಮುಗಿಸ್ಕೋಬಹುದು 18/12/2019. Therefore, unless the appellant makes out a change in circumstance, he cannot. He is not entitled to suspension of sentence and bail. Appellant under this application has, which is filed in the year 2020, has claimed that he is seeking the suspension of sentence and bail on the medical ground of his mother. The application filed on the same ground was dismissed on 18/12/2019. What is her present medical condition? No material is placed to show what was her present medical condition. You know, what is that? ಏನಂತ ಹೇಳಿದ್ದಾರೆ ಎಲಿಮೆಂಟ್? ಆಸ್ಟೋಪೊರೋಸಿಸ್, ಆಸ್ಟೋಪೈಟೋಸಿಸ್. ಏನು ಬೇರೆ ಮಕ್ಕಳಿಲ್ವಾ ಅವ್ರಿಗೆ? ರೇಷನ್ ಕಾರ್ಡ್ ಹಾಕಿಲ್ಲ ಅವ್ರು ಯಾರ ಜೊತೆಗಿದ್ರು ಅಂತ ತೋರಿಸೋದಕ್ಕೆ. ನಥಿಂಗ್ ಇಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಟು ಶೋ ದಟ್ applicant. She was also one of the accused, alva? She is also mother of the applicant was appellant number. Appellant number. Who was the father? It seems he died. Appellant number was appellant number 2 before this court. She was granted suspension of sentence. Nothing is produced to show that she has no other children and about her present medical conditions. Under the circumstances, there are no grounds to reconsider the matter. Therefore, I have not presented report. The application is dismissed. List for final hearing on. List for a restaurant for final hearing on. Before vacation, ಮಾಡಿಸ್ಕೊಟ್ಟಿದ್ರೆ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಅವ್ರದ್ದೇನು ಹರೀಶ್ ಕುಮಾರ್ ಅವ್ರ ಬೆಂಚಿಗೆ ಬರುತ್ತಾ ಇದು? ಈಗ ಯಾವ ಬೆಂಚಿಗೆ ಹೋಗುತ್ತೆ? Prayer column, appeal memo or your prayer column of what? Had you filed any application before the trial court? 25 is pending. Here you have filed. Correct. Then what is the use of amending the prayer column unless you make an application either before the trial court or before this court? No, this is against final order. It keeps pending. That is disposed of. How that application could be pending? You could have filed application here only for if you are not filed before the trial court, because they are not filing. You could have filed a separate application here. Other side is not appearing. Sheshadri D. Aviator. Permit the amendment. They are not filed assets and liabilities statement. Respondent anta idella, they have filed. But is a mistake. Yes, we saw only your assets and liability statement. Respondent anta bardiddare. Advocate for ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಕನ್ಸುತ್ತೆ. In this matter, assets and liabilities, affidavit regarding assets and liabilities filed by the respondent is not forthcoming. Whereas the appellant's affidavit in that regard is found on record. The registry shall clarify the same. You could have sought separate application here under section 25. You take instructions. Otherwise, how it is going to help you? prayer column in the appeal memo. What is the material to show that you had made this prayer before the trial court? How much you had claimed before the trial court? Otherwise, argue this matter along with the main matter. Records are received. You argue this matter. We are not very convinced about amending the appeal memo. There should be some prayer in the trial court, or there should be some application here seeking permanent elimination. As requested by the appellant's counsel, and I did not find out on the trial court. As requested by the appellant's counsel, list down. We'll be able to do that before vacation. Right. Yeah. 18th one.
Number 8. Should be capital.
Including applicants are all purchasers. What is that? Depositors. Yes, sir. What is? Yeah, no objection. They want to get impleaded as? There are so many applications. So why did you not seek your impleadment in the original proceedings itself? Now we want to oppose this appeal. Now, under this, the attachment order is made confirmed. Is confirmed, right? How they are interested in this? Correct. No, how can we ask? Competent authority has to distribute that. Correct. Now here we have to examine whether this confirmation order is right, correct or incorrect. Now, at the most we can oppose it, that, but you cannot seek any release of amount, release of the amount in the hands of this court. Correct, madam. Now they have come before this court challenging the order making the attachment absolute. Now we are not going to distribute the money to anybody. You can oppose his prayer. ಎಷ್ಟೊಂದು applications ಅವೆಲ್ಲ ಅಲ್ಲಿದಾವ?
1/23 ಇಂದ ಇಲ್ಲಿದಾನೆ.
Statement of who has filed statement of objections? State has filed. 1/2022.
ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇಲ್ಲಿದೆ ಮೇಡಮ್, ಅದ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತಪ್ಪಾಗಿದೆ. ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇಲ್ಲಿ
A1/2022 for state. Correct. Correct. Where is the where are the applications? Because
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಎಲ್ಲ
ಎಲ್ಲ ಇದ್ರಲ್ಲೇ ಇದೆಯಾ? Have you gone through that? Whether they are all depositors? Party respondent number 3. Yeah, not. Why have you not served copies on him? ಎಲ್ಲರೂ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಅಂತಾನೆ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಬರ್ತೀವಿ ಅಂತ ಕೇಳ್ತಾರಲ್ಲ. Include him as a respondent. All applications are filed on the same day, 19/9/2023. Then all of you wanted to come on record as respondent only. See your applications. You may not be aware. All are filed by the same advocate. ಮತ್ತೆ ಎಲ್ಲದ್ರಲ್ಲೂ ಅದರ್ advocates ಅಂದ್ರೆ ಗೊತ್ತಿರ್ಲಿಕ್ಕಿಲ್ಲ, but you represent all the applicants. ಅಲ್ಲಿ ಬರ್ದಿ ಇಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ, ಕಾಪಿ ಅಂಡ್ ಪೇಸ್ಟ್ ಮಾಡಿರ್ತೀರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. What is this? Application under section what is this IA 5 of 2023? Could we please kindly direct original response authority authority to return the EMD amount of. So you in the auction purchase you bid for that. You have deposited the amount. So you don't want to let them fight amongst themselves, antana. How much is that? Each of them are. Now this case has to be decided. For purchasers, they borrow money from some banks and correct, we have gone through the order sheet. It said despite that the competent authority has issued. Now, previous order sheet shows that second time it was put for sale and that special officer was directed to be present. Then it is said that these are intertwined with some ED proceedings, therefore he need not be present. It appears there is no second notice on the concept. You coordinate, you share the copies and it is for your benefit. IA sale, IA2 for stay of sale, P2, P22 for dispensation of notice to R2. Why you want dispensation? Who has IA 1, 2, 3 are for 3 and 4. IA 1 to 4 are for impleading. Then what is this dispensation of notice to R2? One second. Who is R2? Oh, your own company. But notice has to go no other dispensation tomorrow. You only are the director of that company. But ಹೋಗ್ಬೇಕಲ್ಲ ನಾಳೆ ಅವ್ರಿಗೆ. What do you say? Company ಹೋಗ್ಬೇಕಾಗತ್ತೆ. Tomorrow somebody may come and say that they were not represented. ಪಾರ್ಟಿಗೆ ಹೋಗ್ಬೇಕಾ? Who is R3? Directorate of Enforcement. ಯಾರು ಇದ್ದಾರೆ? ED penal advocate ಯಾರು? Who is the ED penal advocate here? Prasanna Kumar. There is somebody is there here. Verify ಮಾಡಿ. Otherwise we will issue notice. ಅದಕ್ಕರ್ ದೇಶಪಾಂಡೆ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. Is that very sure? ಅದಕ್ಕರ್ ದೇಶಪಾಂಡೆ ಇದ್ದಾರಾ? ಹಂಗಂದ್ರೆ ಅವ್ರ ಕಾಪಿ ಸರ್. Verifying the records and hearing, it is found that notice to R2 is necessary. R2 needs to be heard in the matter. Therefore, IAP of 2022 for dispensation of notice is rejected. You are for competent authority. You are the ಬೇರೆ ಹೆಸರು ವಾಣಿ H ಅಂತ ಕಳ್ಸಿದ್ರೆ R1.
Kiran.
ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿಗೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಅಪಾಯಿಂಟ್ ಮಾಡಿರ್ತಾರ ಈಚ್ ಕೇಸ್ ಅಲ್ಲಿ ಯು ಆರ್ ರೆಪ್ರೆಸೆಂಟ್ ಆಸ್ ಎ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಆರ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಟ್ ಸ್ಪೆಷಲ್ additional advocates under seeks time to submits that copies of IA 1 to 4 of 2023 are not served and respond number 1. Applicant's counsel shall serve the copies on him. What is this IA 5 for direction 5 and 6? Adu nimde alva. So not only 1 to 4, you have to serve 1 to 8. 1 to 8 anta 1 to 8 of 2023. Okay. Stay application. R3 notice. Shri Madhukar Deshpande, learned standing counsel for respond number 2 is requested to notice for respond number 2. 3. I'm sorry, made it. Respond number 3. Appellant's counsel shall serve the copies on him. Registration show is name in the copies accordingly. We shall find the law of occurrence for each. 10 days. Okay. ಇದು ಇನ್ನೂ ಏನೇನೋ ಎಷ್ಟೊಂದು ಅಪ್ಲಿಕೇಶನ್ ನೋಟಿಸ್ ಆರ್ಡರ್ಡ್ ಆನ್ ನಾಟ್ ಆರ್ಡರ್ಡ್ ಆನ್ ಫ್ರೀ ಅದು R3 ಮುಗೀತಲ್ಲ ಅದು ದಟ್ ಅಬ್ಸರ್ವೇಷನ್ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಫೈಲ್ ಬೈ ದ ಅಪೆಲೆಂಟ್ ಇದೆಲ್ಲ ಆಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ when you examine if those there is possibility for withdrawal they can withdraw because these proceedings have to be over ನೋಡಿ ಅದು ಏನಿದೆ just check it okay list on order last R2 ಗೆ ಸರಿ issue notice to R2 list on ಏನು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ವಲ್ರಿ ಓದ್ ತೋರಿಸಿ 28/9 ನಲ್ಲಿ then where is the need for extension One second, we'll see if that is. What is the date of that order? Please tell the date of order. 21st April. Heard on IA 1 of 2022. 1 second. Heard on IA 1 of 2022 an application seeking stay. Adella submissions record ಮಾಡಿದ್ರು which is in the court's property address cannot be sold etc. We have considered the submissions of both sides. Repeatedly, appellant has received rupees 400 crores from the public and has failed to return the aforesaid amount etc. Powers of the special court etc. adella ಹೇಳಿದ್ರು. Therefore, state government subject to the orders which may be passed to read by the so IA 1 illu disposed of ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ನಮ್ಮ ರಿಜಿಸ್ಟ್ರಿಯರ್ ನಾವು we have to clarify just wait ನಮ್ಮ ರಿಜಿಸ್ಟ್ರಿಯರ್ ಅವನೇ ಲಿಸ್ಟ್ ಮಾಡ್ತಾ ಹೋಗ್ತಾರೆ ಅಲ್ಲ IA 2 of 2022 IA 1 is disposed of. They have filed another application, IA 2 of 2022, and that is pending for more than 1 year. Correct. Now, there is no orders on IA 2 of 2022. IA 1 of 2022 is disposed of. Some with some arrangement. Some conditional order is passed. Why have you filed again IA 2 of they issued another notice. And then last time issue notice to R2. You have to pay the process to R2. Let us see. Yeah, so many other cases below that. Yes, 8 1. Not January. Non-filing of statement of objection 8.1. IA 2 of 2022 per se. They same thing, alva. And non-compliance of office objection based on memo. Process memo. ನೀವು ಈಗ ಎಲ್ಲ ಕೇಸಲ್ಲೂ you have to pay the process fee. Sale notice per stay. Sale notice non-filing of objection. ಎಲ್ಲದರಲ್ಲೂ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಅವರೇ ಇದ್ದಾರಾ? ಕೊಡಿ ಒಂದು ಇನ್ನೊಂದು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಕೊಡಿ. There are R2 and R3 in all the matters. Correct. But other matters ಅಲ್ಲಿ competent authority alone had taken notice. Notice not ordered to R3 ಅಂತ ಇದೆ. No, is it cost title is same in all the cases? In all the cases. Correct. Competent authority. Issue notice to respond ಆಗ್ಬಿಟ್ಟು ಇನ್ನು ಇದರಲ್ಲೆಲ್ಲ ಅದೆಲ್ಲ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳಿದೀರಾ ನೀವು? ಅದೊಂದ್ರಲ್ಲಿ ಒಂದೊಂದ್ ತರ ಮಾಡ್ತಾ ಹೋಗಿದ್ದೀರಲ್ರಿ. ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಈಸ್ ಅಂದ್ರೆ ಇನ್ ವಿಚ್ ಅಪ್ಲಿಕೇಶನ್? 8.4, 8.5, 8.6 go for dispensation. Regarding that ಅಂತ ಮಾಡುದು 8.8 ಅಲ್ಲೂ ಇದೆ. ಇದು ಒಂದೊಂದ್ರಲ್ಲಿ ಬರ್ಕೊಳ್ತಾರೆ. 8.4, 8.5, 8.6, 8.8, 8.8, 8. No, actually 8.13, 14, 15, 17, 22 memo for dispensation. 23 I was also there. 23 Eastern. As respond number 2 is a necessary party. As respond number 2 needs to be added in these matters. The applications and memo filed in these cases for dispensation of notice to respond number 2 are rejected. Issue notice to respond number the purpose. ಅದಕ್ಕಿಂತ ಮೊದಲು ಅದೇ ಮಧುಕರ್ ಇದೆ ಅಂತ ಹೇಳುತ್ತಲ್ಲ. In all these matters ಎಲ್ಲದರಲ್ಲೂ ಇದ್ದಾರೆ. ಹಾಗೆ ಮಾಡ್ಕೊಂಡ್ಬಿಡೋಣ. In all these matters ಶ್ರೀ ಮಧುಕರ್ ದೇಶಪಾಂಡೆ ಒಂದ್ಸಲ ಅದೆಲ್ಲ ಹಾಕೊಂಡ್ಬಿಡಿ. ಆಮೇಲೆ issue notice to respond number 2 if needful is done. Other office objection can be complied before next date. List on 8.1 ಎಲ್ಲದರಲ್ಲೂ ಅಷ್ಟೇ. ಆಮೇಲೆ yes. You have filed application. They have deposited the entire amount. Substantial question of law in appeal is not admitted. Now a question formulate ಮಾಡಿದಂಗಿದೆ ಅದರಲ್ಲಿ. ಅಲ್ಲಿ there is one mistake, we will correct that. In the order dated 24/7 whether ಅನ್ನೋದು ಒಂದು ವರ್ಡ್ ಬಿಟ್ಟೋಗಿದೆ. In determining the age of deceased at 55 despite in exhibit P6 the service register in that regard whether the commissioner has committed perversity ಅಂತ ಆಗಬೇಕು. whether ಅನ್ನೋದು ಒಂದು omit ಆಗಿದೆ. ಅದು ಒಂದೇ MFA number 8629 ಅಲ್ಲಿ ನಾವೇ ಮಾಡಿದ್ವಿ. ಕರೆಕ್ಟ್ ಅಲ್ಲಿ ಟೈಪಿಂಗ್ ಎರರ್ ಅದು ಒಮಿಟ್ ಆಗಿದೆ ಅಷ್ಟೇ. ನಾನು ಕರೆಕ್ಟ್ it is noticed that while formulating the substantial question of law in MF number 8629 of 2022 in the first question word whether is accidentally omitted, the same needs to be corrected and corrected accordingly. ಪಾಠ ಆಗೋಗಿದೆಯಾ? ಯಾರಿಗಿದೆ ಇದು? Non-filing of explanation of abbreviations in exhibit B20 salary certificate. What ಹೇಳಿದ್ದದು? Heard in part. This was regarding admission. Learned counsel for the appellant seeks time to submit the explanation of abbreviation in exhibit P20, the salary certificate. ಅದಾದ್ಮೇಲೆ ಅಡ್ಮಿಟ್ ಮಾಡಿದೀವಿ ನಾವು. ಏನಾದ್ರು ಹೇಳಿದ್ರ ಅವಾಗ? Now that does not survive. Night duty ಅಲ್ಲ, NTD ನ? ಏನದು NTD ಅಂತ? NTD, night duty ಅಲ್ಲ. ನಾವು ಟೈಮ್ ಕೇಳ್ತಾ ಇದಾರಲ್ಲ. ಎಷ್ಟು ಪೇಮೆಂಟ್ ಆಗಿಲ್ಲ? No, nothing is paid to you. Correct. What was the award amount? 20,37,079. So, ಯಾವ್ದು ನೀವು ಪೇಮೆಂಟ್ ಆಗಿಲ್ಲ ಔಟ್ ಆಫ್ ದ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದಾರಾ? ಕೊಟ್ಟಿದ್ದೀವಿ. We'll have it on some other day because he says senior ಪಾರ್ಟ್ರಾಡ್ ಅಂತ ಅದು ಪಾರ್ಟ್ರಾಡ್ ಆಗಿದ್ದು ಇದ್ರ ಮೇಲೆ ಅಡ್ಮಿಷನ್ ಮೇಲೆ, ನಾಟ್ ಆನ್ ದ ಮೇನ್ ಮ್ಯಾಟರ್. ದೆನ್ ಕರೆಕ್ಟ್. ಈಗ ಅವ್ರು ಇಲ್ವಲ್ಲ, ಹೌ ಟು ಹಿಯರ್ ಇಟ್? ಯಾವಾಗ ಬರ್ತಾರೆ? Not on to IA2 can be considered along with the main matter. No, IA2 ಅಲ್ಲ ಎಷ್ಟು? IA2 of 2022 shall be considered along with the main matter for final hearing. List on. Hold.
Number 10. Mahabaleshwara Ashok N. Patil.
Yeah, not preferred anything. How much is the award amount? There was whole claimant. 40%. ಅಂದ್ರೆ rest of it is ordered to be invested. Return the TCR to the tribunal to enable the appellant to seek the release of the amount in deposit. Soon after the purpose is over, the tribunal shall resubmit the records. IA1 of 2023 is disposed of accordingly. Admit ಆಗಿದೆಯಾ? Resubmission of the TCR.
Number 11. D. Lakshmi Shah.
$47 days. Notice ಹೋಗಿಲ್ಲ. There is delay. How much is the award amount? $30,10,000. Issue notice of response. Subject to the appellant depositing 50% of the award amount before the tribunal. The date of this order. KSRTC. List on.
61. Number 12. D. Lakshmi Shah.
That's 70,000. ಅದು ಮೊದಲಿಂದ ಸೇಮ್ ಕೇಸ್ ಮೊದಲಿಂದ ಕೊಡಿದ್ರೆ ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ಸೇಮ್ 50% ಡೆಪಾಸಿಟ್ till next year. Shastra notice to R1 is dispensed with. What is there? What do you say for condemnation of delay? R2 ನೇ delay ಏನಾದ್ರು serious objection ಇದೆಯಾ ನಿಮ್ಗೆ? Case of injury 108 days. Have any objection for condemnation of delay? No, it can be condoned or what is that? In interest of? ಒಂದೇ ಇಲ್ಲ 4,29,000 is the award. Not presentation for the appellant.
Okay.
ಇದೆಲ್ಲ ಇನ್ವೇರಿಯಬ್ಲಿ ಡಿಲೇ ಇದ್ದೇ ಬಿಟ್ಟಿರುತ್ತೆ. What is the award amount? 15,81,700. Issue notice to the response. ಇಂದ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಯುನೈಟೆಡ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಅಂತ ಇದೆ ಅಲ್ಲ, ನಿಮ್ ಇನ್ಶೂರರ್ ಅಥವಾ ಬೇರೆ ಎರಡು ವೆಹಿಕಲ್ ಇನ್ವಾಲ್ವ್ ಆಗಿದೆ? 2 vehicles. This United India Insurance Company is for the other vehicle. ನಿಮ್ದು ಸೆಲ್ಫ್ ಇನ್ಶೂರೆನ್ಸ್? United India Insurance carrier. Anybody? United India Insurance Company ಅವರು? Connected appeal ಅಲ್ಲಿ ಬೇರೆಯವ್ರ appeal ಅಲ್ಲಿ ಯಾವಾಗ ಪೋಸ್ಟ್ ಆಗಿದೆ? ನಂಬರ್ ಹೇಳಿ ಹಾಗಾದ್ರೆ. They have preferred appeal, claimants have preferred. That Itara should try to do. It is submitted that this matter is connected to MIP number so and so. Please put the matters together. ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆ ಆ ಕೇಸಲ್ಲಿ. ಹಾಗಾದ್ರೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿ ಆಮೇಲೆ ಕನೆಕ್ಟ್ ಮಾಡಕ್ ಹೇಳೋಣ. Subject to appellant depositing 50% of the award amount because of the within 6 weeks from the date of this order. It is submitted that this matter is connected to MFA number Bharatpuri. Number so and so. We put the matters together on after verification 16. ಅವ್ರಿಗೆ ಎಲ್ಲರಿಗೂ ಬರ್ತಾ ಇದೆ. Before the tribunal within 6 weeks. Yes, sir. Sangamesh RB. This delay. Yes. Response 4 and 5 are entitled for rupees 87,90,000. Petitioners. Petitioner and response 4 and 5. Out of the remaining petitioner is Lokesh, husband of the 4 and 5 are mother and father. So by this time he has remarried. Three years. 72, 71. So at least mother and husband should have been given equal compensation. At least. What was she? 15, 50 or 15? You guys want interim stay for release? So according to you, at least he is entitled to some amount. Why there should be entire stay? He has already taken. Oh. Issue notice for the respondents. Interim stay of the what? So far it relates to release of with 30 lakhs. 30 lakhs to 30 lakhs to claimant / respond number. Here is respond number 1. Payment before the trial court, before the tribunal. Interim step is the release of 30 lakhs to the claimant before the tribunal. Till further orders. Notice ಅಂತ ಬರಲ್ವಾ? Issue notice for response ಅದಾದ್ಮೇಲೆ. 16.
P. Vijay Kumar.
My lord, I am for the appellant, my lord. This appeal is by the KSRTC challenging the contributory negligence fixed on the KSRTC. There was an accident between the car and the motorcycle. They met with an
How much contributory negligence is fixed to you?
30%. 30% is fixed on the KSRTC. Actually, our vehicle is not involved in the accident. And our liability is about 15 lakh 30,000. Total award is my lord 50 lakh 63,000.
The execution of the award. So far it relates to the liability of the appellant. Subject to the appellant depositing 50% of its liability before the 50% of the liability apportion to the appellant before the tribunal within 6 weeks from the date of this order. This one. Yes.
Much of it.
Number 17.
My lord, this appeal is by the KSRTC, my lord, challenging negligence. My lord, the rider of the motorcycle who came from opposite direction suddenly took U-turn and dashed against our bus.
ಒಂದು ಗೊತ್ತಾಗೋದಿಲ್ಲ ಎಲ್ಲಾ ರೈಡರ್ಸ್ KSRTC ಬಸ್ಸಿಗೆ ಯಾಕೆ ಹೊಡಿತಾರೆ ಅಂತ ಇಷ್ಟೊಂದು ಗಾಡಿಗಳು ಓಡಾಡ್ತಿರ್ತಾರೆ.
ಈಸಿಯಾಗಿ ಕಾಂಪನ್ಸೇಷನ್ ಸಿಗುತ್ತೆ ಅಂತ ಬೇರೆ ಕಡೆ ಆದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
ನಿಮ್ದೇನ್ ಸಿಗುತ್ತೆ ಈಸಿಯಾಗಿ ಬೇರೆಯವರಾದ್ರೆ
ಅವ್ರಿಗೆ ಕ್ಲೈಮೆಂಟ್ಗೆ
ಕೊಡ್ತೀರಿ ಕ್ಲೈಮೆಂಟ್ಗೆನೆ KSRTC ಅವ್ರದಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೋಬೇಕು. ಇಶ್ಯೂ ನೋಟಿಸ್
ಈಗ ಪ್ರೀವಿಯಸ್ ಕೇಸಲ್ಲಿ ನಮ್ಮ ವೆಹಿಕಲ್ ಇನ್ವಾಲ್ವ್ ಆಗಿಲ್ಲ.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಕರೆಸ್ಪಾಂಡೆನ್ಸ್ ನಿಮ್ಗೆ ಎಷ್ಟು ಲಯಬಿಲಿಟಿ ಎಂಟೈರ್ ಲಯಬಿಲಿಟೀಸ್
ಎಂಟೈರ್ ಲಯಬಿಲಿಟಿ ಮೇಡಮ್ ಎಂಟೈರ್ ಲಯಬಿಲಿಟಿ
20 lakhs
20,056
response
056 with 9% interest.
Till next hearing date, subject to the appellant depositing 50% of the award amount before the tribunal within 6 weeks from the date of this order. List down.
Much of it.
Number 18.
the owner's appeal. Liability is fastened to you. And owner on what ground? 56,61,271. You are only on the point of quantum, or there was no insurance. Manager United. Occupant of the car also, no? Yaar United India Insurance Company, yaar is it? Yaar is it? Yaar in honeymoon, you are not there for United India Insurance. Yaar, na tagoli, yaar is it? You are a present United India Insurance Company? You are a present. Shri Arun Pala for understanding council. Sir, the copies are in. As for respond number 6 is requested to know accept notice for respond number 6. Is permitted to file the wakalat in the registry within 2 weeks. Appellant's counsel shall serve the copies on him. Registry shall show his name in the copies accordingly. Issue notice to respondents 1 to 5 and 7. Again, interim stay email or execute ಮಾಡೋದಿಲ್ಲ ನಿಮ್ಮ ಮೇಲೆ ಹೋಗಿದ್ರೆ you want interim stay ಮತ್ತೆ ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕಲ್ಲ ಹಾಗಿದ್ರೆ ಏನು you are what is your occupation this ಇಲ್ಲ ನೀವು ಫ್ಲೀಟ್ ಓನರೇ car number so and so. New car owner, huh? Car was driven by whom? Appellant only. ಯಾಕೆ ಇವತ್ತು ಮಾಡೋದಿಲ್ಲ ನಿಮ್ಮ ಮೇಲೆ ಹೋಗಿ ಬರ್ಲಿ ಬಿಡಿ ನೋಟಿಸ್ ಹೌ ಡು ದೇ ರಿಕವರ್ ನಿಮ್ಗೆ ಏನಿದೆ ರಿಕವರ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಕಾರ ಒಂದ್ ಬಿಟ್ಟು ಬೇರೆ ಏನಾರ ಇದೆ ಅವರೇನು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋದಿಲ್ಲ ಅದನ್ನ ಇಶ್ಯೂ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಅಂತ ಮಾಡಿ ಲಿಸ್ಟ್ probably ಅವರು ಏನಾದ್ರು ಅಪೀಲ್ ಹಾಕಿರ್ತಾರೆ ನೋಡಿ whether they have filed appeal claimants probably they might also have filed appeal. Notice ಮಾಡಿ stay ಮಾಡೋಣ there is delay ಇಲ್ವಲ್ಲ whom did you examine ನಾವ್ ಇಲ್ಲಿ ಮಾಡೋದಿಲ್ಲ ರವಿಶಂಕರ್ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳಿ ದಿಸ್ ಇಸ್ ಫ್ರಮ್ ಮದ್ದೂರ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಮದ್ದೂರ್ ನಾಟ್ ಎಕ್ಸಾಮಿನ್ ಅಲ್ಲಿ ಇನ್ವೆಸ್ಟ್ ಮಾಡಕ್ ಹೇಳ್ತೀವಿ ಕರೆಕ್ಟ್ ರೀ ನಿಮ್ಗೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಆಫೀಸ್ ಇದ್ದಿದ್ದಲ್ಲಿ ಮ್ಯಾನೇಜರ್ ಓರಿಯೆಂಟಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಬಂಡೆ ಯಾಕೆ ನೀವು why you want everything to happen in Bangalore only capital city ಏನು ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ ಲಯಬಿಲಿಟಿನ Alien rider was not covered. Not stay of execution subject to the appellant depositing. I 25%. 25% of the award amount before the judgment within 4 weeks from the date of the receipt of the copy of this order. On such deposit, the tribunal shall invest the said amount in FD for a period of 1 year. I number 1 of 120 is disposed of the stock. 16. What are the other proceedings pending between the parties? Any other proceedings were pending? Marriage registration certificate, marriage invitation. Respondent had not contested the matter. ಯಾಕೆ notice was served or ಅಲ್ಲ ಏನ್ refused ಅಂತ ಬಂದಿತ್ತಾ ಏನಂತ ಬಂದಿತ್ತ served she had received the notice. Not chosen to appear before the court. ನಮಗೆ ಎರಡು this is from Bangalore rural district where she resides ತಮಿಳುನಾಡಿನಲ್ಲಿರೋದಾ ಅಡ್ರೆಸ್ ಕರೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಏನು what is that proof of address you have given? What is the proof of address you have given? ಅವ್ರದ್ದು ಹಾಕಿದ್ದೀರಾ ಇದ್ರಲ್ಲಿ ರೆಕಾರ್ಡ್ ಇಲ್ಲ at least marriage invitation card ನಲ್ಲರ now she is with her parents. Issue notice to the respondent, call for TCR. Issue notice to the respondent, call for TCR.
Number 21. Please, Madam.
ಏನಂತ ನೋಡೋಣ ಇದೆ ಒಂದು ಸಂದರ್ಭ ಫಾರ್ ಆಟು
Serial number 22, my lord.
serial number 21. He is the claimant. ಅಲ್ಲ ಈ ಒಂದ್ ನಿಮಿಷ ನೋಡೋಣ ಇದ್ರಲ್ಲಿ ಇನ್ನು ಬೇರೆಯವ್ರಿಗೆ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ ನೀವು ಮಾತ್ರ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರಿ ಏನು ವೆದರ್ ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ ಇಸ್ ಅಲೋಡ್ 3,48,000 ಯಾರ್ ಫಾರ್ ದ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ 3,48,000 together with interest. Case of death or injury? Injury. ಏನು ಯಾಕೆ ಪಾಸ್ವರ್ಡ್ ಕೇಳ್ತಾರೆ whether they want a settlement? ಅವ್ರಿಗೆ ಏನು ಗೊತ್ತು ಎಡ್ಮಿಟ್ ಮಾಡಿ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡೋಣ ಬಂದಿದೆಯಾ ಎಡ್ಮಿಟ್ ಪೋಸ್ಟ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ನೋಟಿಸ್ ಬೇರೆಯವ್ರಿಗೆ ಹೋಗಿತ್ತಾ ಅರುಣ್ ಪನ್ನಪ್ಪ ನೀವು ಒಬ್ರಿಗೆ ಆಯ್ತು ಮೆಮೋ ಆಫ್ ಅಪಿಯರೆನ್ಸ್ ನಾಟ್ ಫೈಲ್ಡ್ HCCP ಇದ್ದಾರೆ ಕೇಸಲ್ಲಿ HCCP is also there. ಯಾವ್ದಾರ ಗವರ್ಮೆಂಟ್ ವೆಹಿಕಲ್ ನಾನು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಹೆಲ್ತ್ ಆಫೀಸರ್ ಇದೇನು ಇಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಅಡ್ಮಿಟ್ ಲಿಸ್ಟ್ ಫೈನಲ್ ನಾನು ಅಪ್ಲಿಕೇಶನ್
For the appellant in this matter, my lord. For enhancement for claimant appeal.
R3. Yes. Yes, sir.
That
Injury.
death, my lord. Basically, it is injury case, my lord. During the pendency of the petition,
When he died.
yes, my lord. During the pendency of
When he
the
died.
petition,
Date of accident was 21/12/2012.
2012, my lord.
When he died.
The tribunal time.
When he
Huh?
died. When he died. Accident was on 21/12/2012.
Yes, my lord.
ತೀರೋಗಿದ್ದಾವಾಗ ಅವರು there are two cases common judgment 12/20
Common rule.
12/28 ಅಲ್ಲಿ ಲಕ್ಷ್ಮಣ್ ಬಗಾರಾಮ್ he was totally disabled it seems. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರೋವಾಗಲೇ ತೀರೋಗಿದ್ದಾರೆ
They have not marked death certificate, my lord. And also,
ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿ ಫೈನಲ್ ಹಿಯರಿಂಗಿಗೆ ಪೋಸ್ಟ್ ಮಾಡಬಹುದಾಗಿದೆ
LCR kept below.
ಬಂದಿದೆ ಆಯ್ತು ಫೈನಲ್
Okay.
ಹಿಯರಿಂಗ್ ಪೋಸ್ಟ್ ಮಾಡೋಣ ಅಡ್ಮಿಟ್ ಪೋಸ್ಟ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ 4/1
Any date may be fixed, my lord.
4/1
Obliged. Obliged.
Number 23. Then Kumar. Amarabindra.
41 years, 35 years. Yes, ಏನ್ ಹೇಳ್ತೀರಾ ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮೈಸೂರು. ದಿಸ್ ಇಸ್ ಫ್ರಮ್ ಮೈಸೂರು ಕೋರ್ಟ್. ಮೊದಲಲ್ಲಿ ಮೀಡಿಯೇಷನ್ ಆಗಿಲ್ವಾ? ಅಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿರ್ತಾರಲ್ಲ. Filed by the petitioner under section so and so is hereby dismissed. I3 filed by the wife under section so and so is allowed in part. The petitioner is directed to pay compensation of this 1 lakh in favor of the respondent. Also directed to pay 5,000 in favor of respondent towards cost of litigation. Maintenance ಅಂತ ಹೇಳಿದ್ರೆ how much he is paying? So comes to submit that. ದುಡ್ಡು ಕೊಡೋದು ಅಂದ್ಕೊಳ್ಳಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಹೇಗೆ? ಅಲ್ಲ ಕರೆಕ್ಟ್, ಇದ್ರಲ್ಲೂ 1 ಲಕ್ಷ ಆರ್ಡರ್ ಆಗಿದೆ ಅಲ್ಲ, ಅಲ್ಲಿ ಹೋಗಿ ಬರ್ಲಿ ಬಿಡು. ಅಲ್ಲ, ಇಫ್ ಯು ಟು ಫೀಲ್ ದಟ್ there is policy, I mean there is chance of settlement, ಹೋಗ್ಲಿ mediation ಗೆ. If it is only to prolong this matter, then we will not refer it. What is your instruction? Are Mysore? Right. Submit that. Refer to mediation. Therefore, the matter is referred to mediation center, Mysore, for mediation. Both parties shall appear before mediation center, Mysore, on ಯಾವತ್ತು appear ಆಗ್ತಾರೆ? On 14/12/2023 at 11 ಗಂಟೆಗೆ ಅಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಗೆ at 12 ಅಂತ ಮಾಡೋಣ. ಅಲ್ಲಿ ಲಾಯರ್ಸ್ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಎಂಗೇಜ್ ಇದ್ರೆ at 12 without any further notice. 14 list after the receipt of mediation. Date ಹೇಳ್ಬಿಡಿ ಇಲ್ಲ list on. Sure, Kumar, R1. Respond number 1. Respond number 1 is Asha Lata ಏನು ಬಂದಿಲ್ವಲ್ಲ ಇಲ್ಲಿ. My 2 appeals, one is MCP. ಎರಡು ಕಾಮನ್ ಆರ್ಡರ್ ಇಲ್ಲ, ಸಪರೇಟ್ ಆರ್ಡರ್. ಇನ್ನೊಂದು ಕೊಡಿ ಏನು ಕನೆಕ್ಟೆಡ್ MC 521. ಎರಡು 520. Why 2 appeals? Counter claim. As respondent in filed by the petitioner is decreed. Divorce is granted. Hereby dissolved. 10 lakhs permanent eligible. Really, but he is not can't direct him to take notices. Then will issue notice. ಬಂದ್ರೆ ಕರ್ಕೊಂಡು ಬನ್ನಿ ಅಷ್ಟೇ. My child was also made party. ಇವಷ್ಟೇ ಮಂಗಳೂರವ್ರು ಮಾಡೋದು. ಹಾಗೆ without including the child also maintenance ಕೂಡ ಆಗುತ್ತೆ. 6 years. ಇದರಲ್ಲಿ ಕಿಶೋರ್ ಕುಮಾರ್ ಫಾರ್ R1 and R2 ಅಂತ issue notice to the respondents list on ಇದರಲ್ಲಿ within time ಅಲ್ಲಿ ಅಲ್ವಾ? No, connected matter is admitted, not this one. Submit issue notice to the respondents. List on 9-1. Connected 24 maybe list on 9-1.
Motion.
Which address was furnished? ಇದರಲ್ಲೆಲ್ಲ ಸ್ವಲ್ಪ ಸೇಮ್ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ಯಾಕೆ ಸರ್ವ್ ಆಗ್ಲಿಲ್ಲ? You demonstrate that. Now we'll admit and call for exams. ಅದೆಲ್ಲ ನಾವು records we'll examine. This has to be he says date may be fixed, you should appear. Right, you have to appear so what? We'll fix a date. Your concession can be recorded. Hard both sides. Impugn judgment in the High Court has allowed the petition of the respondent hearing for against the appellant hearing for dissolution of their marriage on the section on the ground of 1A is cruelty, alva? On the ground of cruelty. The appellant had not contested the matter before the tribunal. Sorry, before the family court, the trial court. The only ground, the main ground of challenge is that notice was not served on the appellant and she was not heard in the matter. Null counsel for the respondent fairly submits. Null counsel for respondent fairly submits that though he disputes the notice, non-service of the dispute, non-service of notice. Yes, if such matter will be remanded for fresh consideration with a condition that the appellant shall appear at the trial court on a stipulated date, and a time frame will be fixed for disposal of the matter. Therefore, since considering the above said the submissions of the trial counsel for the respondent, and as the decree was passed ex parte, it is just an appropriate to set aside the decree to allow the appeal. Just an appropriate to allow the appeal to give an opportunity to the appellant. Hence the following order: the appeal is allowed. The impugn judgment in 26 impugn judgment dated. The judgment in decree dated 23/6/2023 in MC number 26/0/2022 on the file of the first additional principal judge family court Bangalore is hereby set aside. The matter is remanded to the trial court for fresh consideration and giving reasonable opportunity to both the parties. The parties shall appear before the trial court on 4/1/2024 without any further notice. You inform your party without any further notice. She has to file statement of objection. ಅಲ್ಲ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಕೊಡಿ. She shall appear with a statement of objection ಅಂತ ಹೇಳ್ತೀವಿ. Both the parties shall appear ಅಂತ. 17/1/2024. And the appellant shall file her statement of objection in the matter on the date of her appearance only. The trial court shall give reasonable opportunity to both the parties and dispose of the matter as expeditiously as possible. At any rate, vacation ಅಲ್ಲ vacation ಬರುತ್ತಲ್ಲ ಮುಂದೆ ಅಲ್ಲ ಏನು there are issues out of the marriage or ಮಕ್ಕಳಿದಾರ ಏನ್ ಮಾಡಿ you are on that ಅಲ್ಲ ನೀವು and is it your case that suppressing that she was married to you? Is it your case that suppressing? ನೀವು ಹೇಳೋದು ಅದು ಕರೆಕ್ಟ್ ಅನ್ನೋದಾದ್ರೆ ಪಾಪ ಅವ್ರಿಗೇನು ಜಡ್ಜ್ಮೆಂಟ್ ಇರೋದಿಲ್ಲ. All right, now you can go and see. We have given you sufficient time. One second, we have given you the sufficient time. You appear with your statement of objection and lead your evidence on. You cross-examine within Madhya April vacation ಬೇರೆ ಬಂದ್ಬಿಡುತ್ತೆ. Within 6 months from the date of the appearance of the parties. Appearance is on.
And her demand for
See, 970 of 2022 was by you. See, 123 was by her. Her restitution. So, Mysore court. So, on both sides, she examined one more witness. You examined yourself. What are the other proceedings pending? You examined your brother also. Complaint. CC orders and criminal misdemeanors. That's what we are saying.
Complaint given to the respondent. Given to the petitioner. There are complaints filed against each other. Her grievance is my parents.
This, whether they have filed any execution petition for this section 9 application. This model yaar hakodilla adana. Will issue notice ಆಯ್ತು.
Because the review for proceeding for police again
what are the other? That's what we wanted to know. What are the other proceedings pending? ಅಲ್ಲ ಏನು DV Act 498A ಯಾವ್ದು ಇಲ್ವಾ? ಇಲ್ಲಿ ನಾವು ಸ್ಟೇ ಮಾಡಿದ್ರೆ ನೀವು 125 ನಲ್ಲಿ ಪೇಮೆಂಟ್ ಮಾಡೋದು ನಿಲ್ಲಿಸಬಾರ್ದು. Now that 125 is still pending or disposed of? How much is awarded? ಹಾಗಾದ್ರೆ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಮಾಡ್ತೀವಿ ಬೇಕಾದ್ರೆ ಹೋಗ್ತಾರೆ. You sought on what ground? What was that cruelty?
She insists I have a separate residence away from my parents, and my sister should not come to the house. And her great respect, say, presumption, it is true that the family is given to the husband side, have the habit of giving the life, and therefore It cannot be. But that it cannot be. That's right. 42.
The issue I notice to the respondent. Madam, Alpha TCR intends to have the execution of the decree in MC number 123 till next hearing date. Grant only till next. List on Alpha TCR something. Please, yeah, the first matter. I had work on 26, 27, since these two matters arise out of the common segment, they are connected to each other. Adarmele issue notice correspond to the last one. List on
28. P. Subramania.
Chikballapura. 13-1 మరి 13-1 ಅಂತ ಹೇಳಿದಾರೆ 13-1 ಅಲ್ಲಿ ಯಾವ ಗ್ರೌಂಡ್ in the order it is said petition filed under section 13-1 is allowed 13-1 ಅಲ್ಲಿ sub ground ಯಾವುದು it was on the ground of cruelty desertion what was that 13-1 contains so many grounds ಅಷ್ಟೇ ಬರ್ದಿದ್ದಾರೆ ನೀವು ಜಡ್ಜ್ಮೆಂಟ್ ಓದಿದ್ದೀರಾ ತಾನೆ ಯಾವ ಗ್ರೌಂಡ್ ಹೇಳಿದ್ದಾರೆ issue notice to the respondent. ಹೇಗೆ ಕೇವಿಟ್ ಹಾಕಿದಾರಲ್ಲ ಕೇವಿಯೇಟರ್ ಯಾರು 7366 ಯಾರು ಸುಬ್ರಹ್ಮಣ್ಯ ಪಿ ಸುಬ್ರಹ್ಮಣ್ಯ no representation for the respondent caviator heard the appellant's counsel admit call for TCRs interim stay of the execution of the interim decree till further orders. I have 1 of 2023 is discussed accordingly. List of the receipt of ticket. Yes, order the copy. No?
P. Srinivasa.
Who should bring it to the notice of the trial court? Your advocates in the court, trial court also should. What is that?
Entire order sheet is not mentioned that we are calling. As a matter of fact, they cannot say, put the onus on the trial court to solve all that.
Correct. We agree, learned counsel, but you are also officers of the court. You should also submit the assets and liability statement. Affidavit. They had filed both of them had filed the affidavits. This appellant and respondent, their counsel, whether they ask the parties to file the affidavit. Illa, hakilla. It was his case. His petition for divorce. 13-1A cruelty. No? What is the 6 lakhs is ordered? 60 lakhs. So you are challenging both divorce as well as alimony? This is notice to the respondent. Interim stay of the execution of the interim decree. So far, it relates to the granting of divorce decree. You want stay only to that extent, no? ಅರೆ ನಿಮ್ಗೆ ಬರೋ 6 ಲಕ್ಷನೂ ಬರೋದಿಲ್ವಲ್ಲ ಅವಾಗ ಅಲ್ಲ ಕರೆಕ್ಟ್ ಈ 6 ಲಕ್ಷ ತಗೊಂಡು ನೀವು ಮುಂದೆ ಇದನ್ನ ಪರ್ಸೂ ಮಾಡ್ಬೋದಲ್ಲ ಯು ವಾಂಟ್ ದಟ್ ಆಲ್ಸೋ ಟು ಬಿ ಸ್ಟೇಡ್ ಯು ವಾಂಟ್ we wanted to have
So far as it relates to the granting of divorce decree.
Relates to decree of divorce. Decree of divorce. Okay. I number 1 of 2023 is discussed accordingly. On this one, R ಅದಕ್ಕೆ ಹಾಕೋಣ PCR ಜನವರಿ ಅಪಿಯರೆನ್ಸ್ ಇದೆ.
PS, Mr. Ramakrishna.
ನೀವೇನ್ ಮಾಡ್ಬೋದಲ್ರಿ ಏನಿದು ವಾಟ್ ಇಸ್ ದ ಆರ್ಡರ್ ಪಾಸ್ ಬೈ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೈಲ್ ಹತ್ರ ಇದೆ ತಾನೆ ನಿಮ್ಮ ಹತ್ರ ಬಿ ಕಾನ್ಫಿಡೆಂಟ್ ಸ್ವಲ್ಪ ರೆಕಾರ್ಡ್ ನೋಡಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿ ಸೆಕ್ಷನ್ 13(1)(1)A and 1B ಸಿನಾಪ್ಸಿಸ್ ಇದೆ ಅಲ್ಲ ನೋಡಿ ಸೀನಿಯರ್ ಅವರೇ ಬರ್ಬೇಕು ಅಂತ ಹೇಳಿದಾರ ನಾವು ಹಾಗೆಲ್ಲ ಹೇಳಿದ್ವಿ ಯಾರು ಹೂ ಇಸ್ ಯುವರ್ ಸೀನಿಯರ್ ಕಿಶನ್ CS. 2002 marriage. There are children out of the marriage. Petition for restoration of conjugal rights. Filed under section 13(1) is hereby dismissed. Petition filed under section 13(1), 1A and 1B is hereby allowed. Then Special Marriage Act Hindu Marriage Act. ಏನು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರು ಇವರು she had contested or appeared or not appeared ಯಾರೋ appear ಆಗಿದೆ had admit call for PCR issue notice to the respondent history of Intent judgment further orders. ಏನು ಕೇವಿಟ್ ಬೇರೆ ಇದೆ CP ಅಂತೆಲ್ಲ ರೆಸಿಪ್ಟ್ ತೋರಿಸಿಲ್ವಾ ಕಾಸ್ಮಿಸ್ ಬಿಗಿನಿಂಗ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ಕೇವಿಟ್ ಅಂತ ಬರ್ಕೊಂಡು ಇದೆಲ್ಲ ಬರ್ತದೆ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ರೆಸಿಪ್ಟ್ ಆಫ್ TCR. Said before further judgments ಇಲ್ಲ ಡಿಕ್ಟೇಷನ್ ಅಂತ ಹೇಳಿ ನೀವು ಕೊಟ್ಟಿದ್ದು ಹೌದು ಮಾಡಿದ್ರಿ ಏನೋ ನಾವೇ ಪ್ರೆಸೆಂಟ್ ಇರ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೇವೆ. You relied on one Supreme Court judgment ಅಲ್ವಾ you relied on one national Rani's case. So whatever your whole ground is that this is no, it is not a case of we'll do one thing. Take it up at 2:30 ತಗೊಳ್ಳೋಣ. ನಾನು ಫ್ಯಾಕ್ಟ್ಸ್ ಕೊಟ್ಟು ಆಮೇಲೆ ಯಾರೋ ಬೇರೆಯವರು ಅವರು ಸೀನಿಯರ್ ಸಿಟಿಜನ್ಸ್ ಎಲ್ಲ ಹೋಗ್ತಾ ಇದ್ದಾರೆ ಅದು ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲ ಅದನ್ನು ಮೀಡಿಯೇಷನ್ ಅಲ್ಲ ಇಲ್ವಲ್ವಾ ಇದಾರ ಅವರು ಅಪ್ಪಯ್ಯ ಅಂಡ್ ಹೌದು ಇದು Najina party this matter which is partly settled. ಆಯ್ತು ಶುರು ಮಾಡು. ಇಲ್ಲ ಶುರು ಮಾಡು. Serial number 33 at 213. Whom do you represent there? Or by you? Who represents? I. ಹಾ ಕರೆಕ್ಟ್ ಅವ್ರು ಯಾರೋ ಇನ್ನೊಬ್ರು ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಲ್ವಾ? ಇನ್ನೊಂದು ಕೊಡಿ 5745 ಪೇಮೆಂಟ್ಸ್ ಕರೆನ್ಸಿ and awarding MEC number 41 1938. The claimant has preferred ಇದೇ ಫಸ್ಟ್ ಅಪೀಲ್ ಅವ್ರದೇ ಆಮೇಲೆ ನಂತರ ಕರೆಕ್ಟ್ ಬಟ್ ಅದು ಅವ್ರ ಅಪೀಲ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆಗಿದೆ. Has preferred and the owner of the offending vehicle preferred MFA number 4811 of 1215. The Zahir appellant in 745 of 2016 was the claimant. Respondent number 1 and 2 in the said case were respondent number 1 and 2. In MEC number 4119. The file of this is small cause total. The file of 16th edition Judge Court of Small Causes and MACT Bangalore. For the purpose of convenience, the parties are referred to this court according to the ranks of the trial court. On 15/6/2013, TCF mistake ಆಗಿದೆ. In 2013, when the claimant was 2016 at 9 p.m. when the claimant was traveling in bus number K118582 charge sheet is exhibit. Exhibit P3 P2. on 15th December 1562 at 9 p.m. When the claimant was traveling in bus number K11 8582 near Chamundeshwari Textile Factory, Vinayak Nagar, within the limits of Ramnagar Traffic Police Station. While crossing the humps, the claimant was tossed from his seat and dashed against the pipe of the door of the bus and suffered injuries. Regarding the incident, he is not the complaint. Complaint is on Syed Namida. ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದವ್ರು ಬೇರೆ ಯಾರೋ ನಮೀದ್ ಅಂತ ಇದೆ. ರಿಗಾರ್ಡಿಂಗ್ ದ ಆಕ್ಸಿಡೆಂಟ್, ಕಂಪ್ಲೇಂಟ್ ಆಫ್ ಒನ್ ಸೈಯದ್ ನದೀಮ್, Ramnagar Traffic Police registered FIR as per Exhibit P1 in crime number 94 of 13 of the police station against the bus driver. On investigation, the state police filed charge sheet as per Exhibit P2 against the driver of the bus for the offences punishable under section 279 IPC. It was alleged that the driver of the bus, he is also party, the MEC case party, driver of the bus drove the same in rash and negligent manner so as to endanger the human life, which caused the accident and the consequent grievous injuries to the claimant. At the relevant times, respondent number 1 was the registered owner and respondent number 2 was the insurer of the offending bus. Payment filed MEC 4119 of 2013 against the respondents, claiming compensation of 25 lakhs, alleging that the accident occurred due to the absolute negligence on the part of the driver of the bus. He further claimed that due to the accident, he suffered grievous injuries and consequent permanent physical disability. Thereby, he lost his earning capacity. He claimed that the respondents are liable to compensate the damages. The respondents, they have not filed the written statement at all before the trial court. They have not filed the written statement. Respondent number 1, but not filed the written statement. How can you argue all these matters here now?
He claimed that the respondents are liable to compensate the damages.
No. Whether just he deviated, he applied there in my total violation.
Respondents are liable to compensate the damages.
Respondent number 1 did not contest the matter before the tribunal. Cross-examination madilva. Cross-examination was conducted by whom? Auto alone. PW2 was Sudesh MB. This PW2 new cross examination ಮಾಡಿಲ್ಲ. PW3 is doctor. ಅವರಿಂದ only respond number 2 has cross examined. PW1 even RW1 you have not cross examined. RW1 who is RW2 is the RTO. RTO. ಅಲ್ಲಿ ಕೂಡ ಅಷ್ಟೇನೆ. He was also not cross examined there.
It's a matter of trying to be.
Respond number 2 alone contested the matter. Denying the actionable negligence on the part of the driver of the lorry, the driver of the bus, age, occupation, income of the deceased, injuries suffered by him, and his permanent physical disability. Respond number 2 also respond to contended that the vehicle was being operated without valid permit and thereby there was breach of policy condition. Therefore, it was not liable to indemnify the damages. Here to substantiate his claim, the claimant got examined himself as PW1. And this PW2 is eyewitness ಅಂತ ಮಾಡಿದಾರಲ್ವಾ. PW2 is examined as eyewitness. PW2 as the witness to the incident. And when the doctor who treated him as PW3. Respond number 1 did not need any evidence. Respond number 2 examine its legal officer as RW1. Exhibits mark ಆಗಿದ್ದು ಹೇಳಿದ್ನಲ್ಲ. So on behalf of the claimant, exhibit P1 to P15 over there. And then respond number 1 did not need any evidence. The legal manager of respond number 2 was examined as RW1. The concerned RTO was examined as RW2 to substantiate its claim that the vehicle was being operated without route permit. The tribunal, on behalf of respondent to exhibit R1 to R6 or not, the tribunal, on hearing the parties, by the impugned award, relying on the claimant's evidence and the police records, held that the accident occurred due to the actionable negligence on the part of the driver of bus number K118582. The tribunal, relying on the evidence of the claimant PW1 and PW3, the doctor, assessed the permanent physical disability of the claimant at 8% to the whole body. Considered his age as 43 years. Applied 14 multiplier. Assess the income of the Claimant had notionally at rupees 7,000 per month. Per month. The tribunal assessed the loss of future income. The tribunal awarded sum of 94,080 on the head of loss of future income. The tribunal in all assessed the compensation at 2,86,080 on different heads as per the table below, page 17 and 11. Tribunal relying on the evidence of RW1 in the exhibit R1 to R3 to R1 to 6 held that the true permit to the vehicle bus in question was from T. Narsipura to Bangalore, but the driver of the bus, first respondent operated the same on Ramnagar road, thereby, therefore, at the time of the accident, there was no permit for the bus in question to operate at Ramnagar, and thereby there is breach of policy condition. Therefore, insurer is not liable to indemnify the damages. Thus, a tribunal fastened the liability to respondent 1, the registered owner, and dismissed the claim petition against respondent number to the insurer. The claimant has challenged the said award both on the ground of adequacy of the compensation awarded, as well as the exoneration of the insurer. The registered owner of the vehicle has challenged the award on the ground of questioning the exoneration of the insurer. He represents owner, alva? Yeah, there is no. No, sorry, owner alla, claimant. He argued on the point of quantum also. After the 24% ತಗೊಂಡಿದ್ದ 8% ಮಾಡಿ ತಪ್ಪು ಅಂತ ಹೇಳಿ ಮಾಡಿ. Submissions of she, so and so another counsel for the claimant. The other judgment or rely ಆಗಿದಾರಲ್ಲ, relying on ನಮ್ಮ ಹೈಕೋರ್ಟಿಗೆ ರಿಲೈ ಆಗಿದ್ರು ಅವರು ಅಷ್ಟೇ. The claimant's counsel, submissions of his counsel, counsel for the claimant. Though the doctor PW3 assess the physical disability of the claimant at 24% 24% of the whole body. The 14% to the whole body. The tribunal, without any justifiable cause, reduced the same to 8%, which is unsustainable. You are at the point of income also, notional income. This is the accident of 2015, Allah. Or 2016. ಅಲ್ಲ ಅದಕ್ಕೆ 13 ಅಲ್ಲ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 16 ಇರ್ಬೇಕಲ್ಲ 2016 ಅಲ್ಲ ಇದಲ್ಲ 13 ಅಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 20,136 ಆಗಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ 2013 ಅಲ್ಲಿ ಈಗ ಕಡಿಮೆ ಇತ್ತಲ್ವಾ ಇನ್ಕಮ್ ಆಗಿದೆ 2013 8,000 the income assessed by the income of the claimant assessed by the tribunal is on the lower side. The compensation awarded on the head the heads of payment suffering. Medical expense ಎಲ್ಲ ನಿಮ್ದು ಕೊಟ್ಟಿಷ್ಟು ಮೇಲೆನೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Heads of payment suffering medical expenses. Last income during the laid-up period. And all other heads is on the lower side. And loss of future income ಕೊಟ್ಟ ಮೇಲೆ ಡಿಸಬಿಲಿಟಿ ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಮ್ಯೂನಿಟೀಸ್ ಇರ್ಬೇಕು ಅಲ್ಲ ಅಮ್ಯೂನಿಟೀಸ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಅಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ ಹ್ಯಾಸ್ 7 ಹೆಡ್ ಮಾಡಿದೆ ದೇ ಹ್ಯಾವ್ ಮೇಡ್ 7 ಹೆಡ್ಸ್ ಅದರಲ್ಲಿ 6 is disability 7 is loss of amenities ಅದು ಎರಡೆರಡು ಯಾಕೆ ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಇನ್ಕಮ್ ಲಾಸ್ ಆಫ್ ಅಮ್ಯೂನಿಟೀಸ್ ಬರುತ್ತೆ ಡಿಸಬಿಲಿಟಿ ಏನದು at the time of the accident, the vehicle had the route permit. That was exonerating the insurer is not sustainable. Okay. Submissions of Shri Kutiga Ramesh Lagat Senior Counsel for on record for response number 1 / RC owner. RC owner. You are only on that point. Only. You are not on any other head, quantum and etc. Interest. Respondent number. Respondent number 2 did not dispute that there was a valid policy, that the vehicle was covered under the valid policy at the time of the accident. It was also not disputed that the vehicle had a permit. Already produced permit as per exhibit P. Policy permit as per exhibit R2 as per R2 and R3 according to respondent number 2 the driver of the bus only deviated from the scheduled route, the stipulated route. That does not amount to no permit at all. No permit at all. At the most, that amounts to deviation from the deviation of the route permit. In case of deviation of route permit, the insurer a defense available illa antira niಮಗೆ you say 149 defense available illa antana in case of motor vehicles act. You are arguing on that point, no? But that defense is not available to them. No. A defense available illa ಅನ್ನೋದು ಒಂದು issue. You are arguing 149 ಅದರಲ್ಲಿ ಆ defense available ಇಲ್ಲ ಅಂತ.
Single
excluding the use of the vehicle for hire or reward where the vehicle is on the date of the contract is not covered by a permit. Okay. Yes. Under such circumstances, the defense under section 149 to A1A is not available to the insurer. The defense under the said provision is available only to the cases where the vehicle was not covered by a permit. Covered by a permit, or the vehicle was used for the purpose other than the one permitted. Therefore, the tribunal committed error in exonerating the insurer. In support of his submission, in point error ishte. Your point is only this much. ಅಲ್ಲ ಅದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಕೊಟ್ರಲ್ಲ ಎಷ್ಟೊಂದು ಎಲ್ಲಿದೆ ಅವ್ರದ್ದು ಯಾವ್ದು ಕೊಡ್ಲಿಲ್ವಲ್ಲ support of his submission he relies on ನೀವು ಒಂದು ಸೀರಿಯಲ್ ನಂಬರ್ ಹಾಕಿಲ್ಲ ಅದಕ್ಕೆ ನಿಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ಗೆ ಸೀರಿಯಲ್ ನಂಬರ್ ಸೀರಿಯಲ್ ಇದು ಸೈಟೇಷನ್ ಅದಲ್ಲ ಅದು 1 2 3 4 judgments you are relied in support of his submission. ಅದಕ್ಕೆ ಹಾಕಿರ್ಲಿಲ್ಲ ಅಲ್ಲ ಇನ್ನೊಂದು ಮಾಡಿದ್ರೆ ಒಂದು ಕ್ವಾರ್ಟರ್ ಸೆಂಚುರಿ ಆಗಿರೋದು he relies on the following judgments ಅದರಲ್ಲಿ ಇದೆ ನೋಡಿ ಅವ್ರದ್ದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ next one. Submissions of Shri so and so other counsel part insurer. Though there was no dispute with regard to the coverage of the vehicle by the policy exhibit R1 exhibit R1 that itself does not entail the liability on the insurer. The insured is bound by the conditions of the policy. Conditions of the policy. ಆ ಕಂಡೀಷನ್ಸ್ ಅಲ್ಲಿ ಒಂದಿರುತ್ತೆ as per the conditions and the statutory defense available to the insurer. Conditions of the policy full stop. The insurer has all the defense available, all the statutory defense available under section 149 of the motor vehicle. ಅಲ್ಲ ಆಯ್ತು ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಲಿಮಿಟೇಷನ್ಸ್ ಲಿಮಿಟೇಷನ್ಸ್ ಅಷ್ಟು ಯೂಸ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ನೀವು ಹೇಳೋದು the policy exhibit R1 the policy in exhibit R1 the policy the clause limitations as to use clearly states that the policy covers use only under a permit. Within the meaning under the permit meaning our change ಮಾಡ್ತಾ ಇದೆ permit. Since the vehicle was operated in violation of the permit condition, there was as good no permit to operate in Ramnagar town. Therefore, thereby there was a clear breach of policy condition and the provisions of section 66 of 66 of the Motor Vehicles Act. Under the circumstances, the insured neither filed its statement of objection nor led any evidence nor cross-examined any of the witnesses. Therefore, for the first time, it is not open to the her to question the to raise all those grounds before this court in the appeal. The trial court rightly exonerated the insurer in view of the opposite facts and circumstances. That judgment does not warrant any interference of this court. ಅಲ್ಲ ಇನ್ನೊಂದು ನಿಮ್ ಕ್ವಾಂಟಮ್ ಮೇಲೆ ನಿಮ್ಗೆ ಸಂಬಂಧನೇ ಇಲ್ಲ ಅಂತ in support of his submission, he relies on the following judgments. National Insurance Company Limited versus Challa Upendra. ಇದರಲ್ಲಿ ನೋಡ್ ಹಾಕೊಂಡಿದ್ರು page 1 ಮೇಲೆ. Will continue the afternoon. ಮದನ ಇಲ್ಲ ಇದು ಮುಂದಿನದಷ್ಟು ಬರ್ಕೊಳ್ಳಿ. On consideration of the submissions of both sides and submission of all the parties and an examination of the material, the question that arises for consideration are: number one, whether the quantum of compensation awarded by the tribunal is just one. Number two, whether the finding of the tribunal that insurer is not liable to indemnify the damages is sustainable. Indemnify the insured. Insured is just one. Okay. Next point. Okay. Analysis regarding quantum. The occurrence of the accident is not in dispute. So far as the negligence on the part of the actionable negligence on the part of the driver of the bus, response number one, the insurer, the RC owner, did not contest the matter or examine the driver of the bus. Admittedly, under Exhibit P2, the driver of the bus was charge sheeted for the offense for the rash and negligent driving and causing grievous injuries to the victim. The trial court, relying on the evidence of the injured claimant, P2, and the police records P12, P5, P6, P6, the police records rightly held that the accident occurred due to the actual negligence on the part of the driver of the bus. Next one. The evidence of PW1 and Dr. PW3 coupled with Exhibit P6, the wound certificate, P13, the IP records, P14, the IP records, P15 next day, show that the claimant had suffered the following injuries. Page number 15 and number L1 of the opposite evidence further shows that the claimant was admitted in Victoria Hospital from 16/6/2013 till 22/6/2013. He was treated as inpatient for a period of 7 days as per the evidence of PW, the devotion to the doctor will continue now. ಅಷ್ಟಾದ್ರೂ ಆಗುತ್ತಲ್ಲ ಅಂತ ಪಕ್ಷ ಎಲ್ಲರೂ ನೋಡಿದ್ರಲ್ಲ ಅವರು ಜುಡಿಷಿಯಲ್ ಅಕಾಡೆಮಿ ಡೈರೆಕ್ಟರ್ ಇನ್ಯಾರು ಟೆಲಿಂಗ್ ದ ಬ್ರದರ್ ಈಗ ಯಾರು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಫೈಲ್ಸ್ ಅಂತ ಬಂದು ಬಿಡ್ತಾರೆ. ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಹೇಳ್ಬಿಡ್ತೀವಿ, ವಿ ಆರ್ ನಾಟ್ ಕನ್ವಿನ್ಸ್ಡ್ ಆಫ್ ಯುವರ್ ಆರ್ಗ್ಯುಮೆಂಟ್. Yes, right. You see, your main submission was that 149(2)(a) ನಲ್ಲಿದೆ ಅಲ್ಲ, ರೂಟ್ ಪರ್ಮಿಟ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಷ್ಟೇ ಅದು ಅಪ್ಲೈ ಆಗುತ್ತೆ. ದಟ್ ಡಿಪೆಂಡ್ಸ್, ಅದರ್ವೈಸ್ ನಾಟ್ ಅಪ್ಲಿಕೇಬಲ್. He referred to the Supreme Court judgment. They are trying to make distinguish on the facts. Known by the Supreme Court judgment and the basic provision of law. ಅದು interstate route and change ಇದೆ ಅಲ್ವಾ? You argued that at length interstate transport. You only said, I mean, either way it goes to taken further.
ಬೇಡ ಅಂದ್ರೆ ತೆಗಿಲ್ಲ.
That matter no. 1 second. ಯಾವ್ದೋ 230 ಮ್ಯಾಟ್ರ್ ಇತ್ತು. ಇದು ಅಪ್ಪಯ್ಯ ಅವ್ರದ್ದು 230. ಅಂತ ಮಾಡಿದ್ವಿ. ಅಲ್ಲ ಅವ್ರೇನು ಹೇಳಿದ್ರಲ್ವಾ ಸರ್. Yes, Mr. Dan is here. It is your matter, no? 230. 33. Their arguments were over. You had to argue.
I stand on, I have now not my. So case file definitely.
But his argument was that cannot be recorded. That they had. You are for respondent number. Whom do you represent? All right, first we'll hear him. Okay, so far as, so that's all your submission. Yes, yes. Subsequently, I have filed another appeal, right? After that, Sitaram we had heard. For what purpose?
Satisfied.
It's not file, copy is not served on you. Oh, there is no signature on this for having served. Whether office says the objection. No, it appears it was not, it is subsequent after this file was sent to us, this is placed itself. So it was not on the appointed day, it was not sent. Saturday, when did you file it? File ಎಲ್ಲ ನಮಗೆ ಬಂದ್ಮೇಲೆ ಮಾಡಿರ್ತಾರೆ ಅನ್ಸುತ್ತೆ. Counter ನಿಂದ ಅಲ್ಲೋಗಿ it was not placed before us. If you have to serve the copy on the other side, who is the advocate on record for this? See, and every party, whether it is correspondent or they were opponent, in fact, it appears you are sailing with the appellant. So you should serve the copy. Correct. Just at least when you are submitting, you should know what you are submitting. Copy kudi irke aita ಆಮೇಲೆ. We can seek your response later. Just what you can follow it. Yes.
stake. The further term to settle it, I can read the proposal of the article. Taking my share of the instruction, I have already reached out my share of the article. For a period of 20 years, actually, very, I submitted the right of the extent and the right. I will borrow them. One direction to all of 99. I did expect God to pass my table. But one day, what satisfaction of it's is on the whole system matter. Please record a person, record document right. In the others, my sense, right? And accordingly, school of the other set. Double segment.
Now, this is again repetition of the same joint memo. What was the need to file it? 1 second, one second. Because he's better. Mr. Ramesh, we'll have your matter tomorrow because here also. It was taken up because Mr. Sitaram Rao had got it posted because his party has come from some other country and tomorrow. So we don't want you to wait. Okay. Yes. And then tomorrow. Yes.
I am one of the owners of the law. There are no certain rights or entitled to the law. What's getting mentioned? I have said, whatever I have now received, satisfies my requirements. I have no claim.
That's simple, no? You need not execute the arbitral award so far as you are concerned. That's all. See, if you say that you have settled the matter with him, that's not necessary to record also. Your claim is satisfied. Under the arbitral award, your claim is satisfied. It rounds down to that. We'll record after hearing whether this could be recorded. This compromise should be admissible under law. If it is admissible, we'll record it.
So far as my entitlement in terms of square feet area, I am entitled to one part. The second is the amount of money that I should perform. So far as both are concerned, I am satisfied. Now we want to get two options for the management. What should be avoid the award? In which way, what are the consequences that if you want to go as left as a victim, we continue. I am not asking what to set aside the award. If you want to set aside the award, for any reason, then only those parties who are there challenging or supporting the award will be available. So while they want to, but I am concerned, I should not be the first situation, whatever good or bad reason. I have now received whatever I have received. Therefore, my entitlement cannot be just to the arbitral proceeding between two other parties of whom I am no longer interested in. And that is why I don't care before you
See, we'll give you one example. In a partition suit, each party is entitled to on each inch of the property unless and until that final decree is drawn. So you are saying that the continuation of the matter between two others should not affect your interest. Right? That was your submission, right?
May affect, not affect. But so far as I am concerned, I have no further claim.
See, you could have simply said that you have no claim. Arbitral award so far you is satisfied. That's all.
Just that. As to what is the amount of receipt and what is the extent and what I have done thereafter. Because I have these are my terrible property. Two large developers. Where I don't want this headache of the others fighting. Or the others are
it is like a purchaser pendant till it alienating the property. Sir, a party fight.
Understanding that, I only concern now.
See, so far as the receipt of the money, there may not be any issue. All right, your claim is satisfied. But you are saying that certain you have received certain portion of the property and you have let it out. Whether these parties who enter into the compromise, whether they will get that or not, that
It can be, I don't think that can be very part of our, but any, it can be also. Consequence will be things, not against everyone. So it is determined in terms of area. So I'm not getting into any of those issues. So I'm saying this is what I have, and this is what I'm satisfied. And therefore I have no further thing while we are what is concerned or we apply this concern. That's all I'm saying. I'm not asking, I'm not asking. What on the basis of my settlement? I'm only saying, please take it on record and notice the fact that all the parties are present today, because of that, they don't understand. But recording that, they're all present.
which date was that? Which 19/9, they have said 19/9. Affidavit, in the affidavit, it appears they said 19.
19.
Respond number 3 is filed by R2, 3 and 5. 3 is represented by R2, GPA.
How about we do first?
So R5 was not there on that day. No, here, learner counsel for the appellants filed in the court a joint memo said to have been signed by respondents 2, 3 and 5. Respondent 3 is represented by GPA holder and respondent 4. Last time we said it is not recorded here, that their presence and their signing is not recorded. You say that there are some signatures, but court has not recorded that. Correct. Now all the 3 of them are present.
All three are present. What is present? And but the fact that they make a statement is not, they are satisfied. After that, not, how long keeping the comment, can be satisfied.
Who are those R3? Who represent them? R3, Firdos. R2, 3 and 5, no? R2? Fauzia Ali Akbar. This Fauzia. Then Firdos, Alish. And 5, Muhammad Irshad Rahmatullah. It's so. Respondents 2, 3 and 5. They are represented by different councils, 3, 2, 3 and 5. 309. 2 to 4, who? Sir, you appear for R1 only. 2 to 4, Hidayatullah appears for R5. Who represent R2 and 4? Earlier, he said they have not approached you ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ. Last time, seniors ಇದ್ದಾರೆ ಅವರ. No, last time you said that the parties whom you were representing, they filed this petition, compromise petition. You said they have not come to you and they have not, you are not aware of this development. Now you have filed a wakalat. Where is the wakalat? Bandidya? What about R4? Yes, R4 ಅಲ್ಲ. 3, 3 ಜನ ಅಲ್ವಾ ಈಗ? Then how can we identify them? You are not on record. Now you want us to record this and take their signature. You have not yet filed wakalat. All right, R5 advocate on record is there. Now her wakalat for R2 has come. But what about R15? Why they say take so much of time only to do these small things? You are a brother, yes. But you are the senior advocate, you should guide us.
Oh, since my learning trend is seen and now still goes on other for he could very well identify.
How he see? They should go to him and get this drafted. If somewhere they go, then why?
Does he now say that his own client should not benefit from our?
Why are you worried about what happens between Mr. Appaya? See, Mr. Counsel, it is between him and his client. Why are you discussing? You cannot win over somebody and say that I am benefited. So therefore, there is a fiduciary relationship between them. They should go to him and file this, okay. But if he goes somebody and file wakalat against the interest of some other person, why should he endorse that compromise? ಬಿಟ್ಟು ಬಿಡಿ ಇದು ಈ ತರ ಹೇಳೋದು ಸರಿ ಅಲ್ಲ. ಅದು ಬಿಡಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಅಲ್ಲ. ಈಗ ಅವರು ರೆಕಾರ್ಡ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. ರೆಕಾರ್ಡ್ ಮಾಡೋದಕ್ಕೆ there are only 2 persons who are on record, who are represented through their counsel. How do we identify the party who is not represented through an advocate? Yes. Do you mean to say that he did not give you the NOC? ಬೇಡ ಅಂದ್ರೆ ಕೊಟ್ಬಿಡಿ ಹೋಗ್ಲಿ, ಅದು ಏನಾಗುತ್ತೆ? Correct. Now at least that's what she could have taken her signature. ಇಲ್ಲೇ ಕೊಡ್ತಿದ್ರು ಅವ್ರ ಎನ್ಒಸಿನ. You said you represent R2 and 3 both. Undertaking will not. ಇಷ್ಟು ಟೈಮ್ ಹೋಗುತ್ತೆ ಇದ್ರಲ್ಲಿ. ಬರೀ ಒಂದ್ ಸ್ಮಾಲ್ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿ. That's why we said. No, it was listed today for further hearing. See, that settlement he had already reported. There was no need to file another affidavit here today for R5. Moreover, she is not R5, she is R2 alva. R3. Yes. Madam, we are saying it is a very simple. Your counsel could have taken your signature on wakalat. Here only he was giving NOC. He could have filed it. They unnecessarily delay the matter. That is different. That is in between you. But here, I don't think Mr. Sitaram Rao objects for giving NOC. Did you object? ಕೊಟ್ಬಿಡಿ ಹೋಗ್ಲಿ ಆಚೆಗೆ. ಇನ್ನು ಹೇಗೆ ನೋಡ್ತಾ ಇದ್ದೀರಾ? ಆಯ್ತು. ದೇ ಆರ್ ನಾಟ್ ಸೇಲಿಂಗ್ ವೆಲ್ ವಿತ್ ದಮ್. ಇಟ್ಸ್ ಆಲ್ವೇಸ್ ಬೆಟರ್ ಟು ಯೂಸ್ ಆಲ್ ದೋಸ್ ಥಿಂಗ್ಸ್. ಇದ್ರಲ್ಲಿ ಕಳ್ಕೊಂಡು ಸುಮ್ಮನೆ ಕಳಿಸ್ಕೊಂಡ್ ಬಿಡೋದು ಒಳ್ಳೇದು. ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಫೈಲ್ ವಕಾಲತ್. ಶಾಲ್ ವಿ ರೆಕಾರ್ಡ್? ಏನ್ ನಿಮ್ಮ ಹೆಸರು? ಏನೋ ಅಲೈಡ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಂತ. ಸಿಗ್ನೇಚರ್ ಇಷ್ಟೊಂದು ಜನರು ಸಿಗ್ನೇಚರ್ ಇದೆ. ಯಾರಂತ ಶ್ರೀಮತಿ ರಿಜಿಸ್ಟ್ರಿ ಹ್ಯಾಸ್ ಪ್ಲೇಸ್ಡ್ ದ ವಕಾಲತ್ ಆಫ್ ಶ್ರೀಮತಿ ಪರೀನಾ Lala filed for respondent number 2 and the affidavit filed by respondent number 5. Respondent number 5. Sir, avre koಟ್ಟು ಕೈ ಬಿಡ್ರಿ ಆ ಕಡೆ ಒಂದು. They want to file NOC ವಕಾಲತ್ ಮಾಡ್ಕೊಳ್ಳಿ ಕೊಟ್ಬಿಡಿ ಆಚೆಗೆ ಹೋಗಿ. ಅಲ್ಲಿ ಬಂದಿದ್ದಾರೆ ನೋಡಿ ಅವರೇನಾ? ಯು ಆರ್ ನಾಟ್ ವಿಲಿಂಗ್ ಟು ಗಿವ್ ವಕಾಲತ್. ಅವ್ರ ಮನೆಗೆಲ್ಲ ಇಲ್ಲೇ ಕುಡಿ ಹಾಕೊಂಡು ಮುಗಿಸ್ಕೊಂಡು ಮುಂದೆ ಕೇಸ್ ಮುಂದೆ ಹೋಗ್ಬೇಕೋ ಇಲ್ವೋ, ಯು ಕ್ಯಾನ್ ಆರ್ಗ್ಯೂ ಆನ್ ದ ಮೆರಿಟ್ಸ್ ಆಫ್ ದ ಕೇಸ್. ಹೇಳಿದಿರ ಅಲ್ಲ, ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಳ್ಳೋಣವೋ ಬೇಡ ಅಂತ ಮಾಡ್ಕೊಳ್ಳೋಣ. ಇದಕ್ಕೆ NOC ತಗೊಂಡಿಲ್ವಾ? ಯಾರು R2 ಹಾಕಿದಾರಲ್ಲ ತಗೊಂಡಿದಾರ? ಕೊಟ್ಟಾಗಿ ಆಯ್ತಲ್ಲ, ಮಾಡ್ಕೊಂಡು ಮುಂದೆ ಹೋಗೋಣ. ಈಗ ವೆದರ್ ದಟ್ ಕಾಂಪ್ರಮೈಸ್ ಇಸ್ ಅಡ್ಮಿಸಿಬಲ್ ಆರ್ ನಾಟ್, ವಿಲ್ examine that and pass the orders.
Registry has placed the wakalat of Srimati Farina,
So ಅಂತ ಯಾರೋ ಹೇಳಿದ್ವಲ್ಲ ಈಗ.
Farina Lala filed for R2 and the affidavit filed by
ನಾವು
R5.
ಶ್ರೀಮತಿ ಪರೀನಾ ಲಾಲಾ ಕೌನ್ಸಿಲ್ ಫೈಲ್ಸ್ ವಕಾಲತ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ಆಲ್ಸೋ. ಅದಕ್ಕೆ ಎಷ್ಟೊಂದು ಇರುತ್ತೆ, ಸೆಕೆಂಡ್ ಸೆಟ್. You have to go to his office and collect it. NOC is giving. ಅಪ್ಪಯ್ಯ ಅವಾಗ್ಲೇ ಹೇಳಿದ್ರು, ಅವ್ರವ್ರ ಕ್ಲೈಂಟ್ ವ್ಯವಹಾರದಲ್ಲಿ ನೀವ್ ಯಾಕೆ ಭಾಗವಹಿಸ್ತೀರಂತ. See, you are also an officer of the court. You are also an officer of the court. You should not meddle into the affairs of an advocate and ನಿಮ್ಗಿಂತ ಅಲ್ಲಿ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಧ್ಯಾನ್ ಅವರು ನಿಂತ್ಕೊಂಡಿದಾರಲ್ಲ. He also could have said so. Why are you so perturbed? Why are you so perturbed? It is not, Mr. Counsel. It is not in the good taste. It is not in the good taste to meddle in the affairs of one advocate and a party, that in the court hall. You go to office, whatever you want to do, you do that. Who will wakalat filed ಅಂತ ಬರ್ಕೋ.
Srimati Farina Lal, learned counsel, files wakalat for.
Number we get so confused. 3 ಅಲ್ಲ, she is respond number 3. She is respond number 3 ಅಲ್ವಾ? ಅದ್ರಲ್ಲಿ ಪಾರ್ಟೀಸ್ ಏನ್ ಗೊತ್ತಾಗ್ತಿರುತ್ತೆ ಇವ್ರು ಮಾಡೋದು. Her name is Firdaus ಅಲ್ವಾ? Respond number 3. Respond number ಯಾರ್ಯಾರು ಇರೋದು 2, 3 and 5 ಅಲ್ವಾ? 2, 3 and 5 and their counsel are present in the court and they are duly identified by their counsel. Response 2, 3 and 5 submit that they have entered into a compromise with the appellant in terms of when was that filed? The compromise petition filed on 8/9. 19th it was recorded. Joint memo na adu? Yes, that was joint memo. 13/9. That memo is dated 13/9.
It was filed on 14/9.
Memo is dated. Compromise petition ಅಂತ ಹೇಳಿಲ್ಲ, ಜಾಯಿಂಟ್ ಮೆಮೋ. ಕಾಂಪ್ರಮೈಸ್ petition ಅಂತ ಹೇಳಿದ್ವಲ್ಲ, ಜಾಯಿಂಟ್ ಮೆಮೋ ಡೇಟೆಡ್ 8 September 2023. 8/9 ಹಾಕೊಂಡಿದ್ದಾರೆ ನೋಡಿ ಅದನ್ನ. ಜಾಯಿಂಟ್ ಮೆಮೋ ಡೇಟೆಡ್ 8/9/2023. 8/9/2023. The said memo is taken on record subject to the admissibility of the same under law. Yes. Heard Shri Dansinappa Lawrence Senior Counsel for advocate R5 on record for respond number 5. Yes, that's all. Your matter. Yes, now you have anything to say further? You have anything to say further? ಆಯ್ತು ಮಾಡಿ ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ತಗೋ. Some affidavit they have filed it today. Again, that is repetition of earlier joint memo. They can go back, ask him. You can send him back. ಆರ್ಡರ್ ಶೀಟಿಗೆ ಸೈನ್ ಮಾಡ್ತಾರೆ ಕಳಿಸ್ಬೋದು. ಯಾಕೆ ಅವ್ರು ವೀಲ್ ಚೇರ್ ಬೌಂಡ್ ಇದ್ದವ್ರನ್ನ ಇಲ್ಲ ಯಾಕೆ ಕೊಡಿಸ್ತಾರೆ? ಎಸ್ ಮಿಸ್ಟರ್ ರಾವ್. Yes, hey. You have to continue your argument. He said he has nothing more to say, that if it is admissible, it can be recorded and the he says according to him the award is satisfied. They are not asking for appellant. He'll consider that whether that is admissible or not under law. That's what he said.
The ultimate prayer is to have made.
You are referring to joint memo dated that earlier joint memo, no? 8 time. ಅದೇನಿಲ್ಲ ಸುಮ್ಮನೆ ಮಲ್ಟಿಪ್ಲೈ ಮಾಡಿ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡಿಸ್ತಾರೆ ಅಷ್ಟೇನೆ. We have to decide on this joint memo. ಅದನ್ನೊಂದು ಬರ್ಕೊಂಡ್ಬಿಡಿ. Since already ಅದ್ರ ಮುಂದೆ ಬರ್ಕೊಂಡ್ಬಿಡಿ. Since already a joint memo 8/9/2023 is filed by way of a compromise petition, the affidavit filed today has no relevance and no bearing in the matter. Yes. Yes. Only the admissibility of the joint memo dated 8/9/2023 has to be examined. Yes. Sorry, 8/9. Yes, you are referring to which paragraph there?
Paragraph 11.
Set aside the judgment and decree dated so and so passed by CPC will judge and modify the arbitral award dated. Yes. Yes.
Yeah.
Yes. Yes.
So far as it relates to the claim of respondent. I have no. Come to. And the question is come back first. Right. Page 3.
Page 3 is. Hmm.
In pursuance of the foregoing, parents have delivered to the respondents 2, 3, 5, full, free and vacant portion of their therapy. Respondents 17,000 money per week. Hotel cover ಮೂರು ಎಂಬತ್ತಲ್ಲಿ deliver ಮಾಡಿದ್ದಾರೆ. Total that cost to share the landowner is 50% of the building. Total building. As per sanction planning, 30,000, which they are required to comply.
Last time we had argued this.
He find out ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಬಂದ್ರೆ ಅವ್ರು
ನಮ್ಮದು ಸೇರಿಸಿ ಡೆಲಿವರ್ ಆಗೋದಿದೆ. ನಮ್ಮ ಬಿಲ್ಡಿಂಗ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಅಂತ ನಮ್ಗೆ ಇಲ್ಲ, ಫ್ಲೋರಿಂಗ್ ಇಲ್ಲ, ಗೋಡೆಗಳು ಇಲ್ಲ. ಇದರಾಗಿ part of the compromise, but they reached to my right. Paragraph. In work. The point of the foregoing, the respondents have limited the appellant. Respondent. But it is. Okay. They are not limited. Limited the appellant to take full, free and vacant portion of the appellant 17,390. Not permitted. ನಮಗೆ ಬಂದಿಲ್ಲ ಇಲ್ಲ ಅವರಿಗೆ. A mischievous statement to be made in the judgment. Second respondent going to hand over the unfinished building, their share of unfinished building. Let him take it, make it right there. Without complying with the legal requirement, I have taken the unfinished building and read so much square feet, belonging to the respondent. ಇಲ್ಲಿದೆ ಯಾವ ಫ್ಲೋರ್ ಇದೆ ಇಷ್ಟ ಬೆಳಕ 42 what they are not setting measure. It is not there yet, our thing is kept aside. Total building is now given to the appellant under these two clauses. And second compromise. And next, I will come later to repeat what I have said.
ಕುತ್ಕೊಳ್ಳಿ ಕೇಳಿ ಪಾರ್ಟೀಸ್. Them to take the sheet. Yes.
So,
Thank you very much.
Yes. Take your seat. Yes.
what is handed over to him? Clause note, entire 17,000 money is in. Actually, he gets 1 times 10 more. I don't know how he gets. Total share of the landlord is 50%. Total landowner share from his previous clause is 17,000 money. Whereas developer gets 17,000.
Correct. According to it was totally 30,000 square feet. According to it was totally 30,000 square feet.
Oh.
So this which paragraphs cancelled?
As six and objection. That leads to the larger area.
No, apart from larger area, you have said all respondents. Sweeping statement. What kind of compromise is this? How can we do it in this manner? Once you file it in the court, it is over. If you-
And
When thereafter the continuity remains. If these two paragraphs are removed, whether continuity is
I'm not in so far as looking like itself. This episode that order. Also there.
let him complete, because we do not know what else he points out in this. Let him, why did he interfere? Let him complete what he wants to say.
Indicate about 54,570
ಅಲ್ಲ ಒಂದು ಸಿಂಪಲ್ ಮೆಮೊ ಹಾಕಿದ್ರು ಹಾಕಿದ್ದಲ್ವಾ. We have received whatever was due to us under the award. The claim against appeal against us may be allowed ಅಂತಾನೋ ಅಥವಾ appeal may so far they may be withdrawn ಅಂತ ಒಂದು ಸಿಂಪಲ್ ಮೆಮೊ ಹಾಕಿದ್ರೆ ಮುಗಿದೋಗಿರೋದಲ್ಲ. Arbitral award so far as these three respondents is satisfied. We have no claim in that ಅಂತ ಅಷ್ಟೇ ಹಾಕಿದ್ರು ಆಗಿರೋದಲ್ವಾ. You came after the memo was filed.
Not taking credit or paying for it, but I'm just saying. The problem is there are some. And you did this instead. That's all.
Yes,
You see, can't go beyond that.
his concern is that.
What is concern? Then stand for something else. Other than them, whatever others who can't be his concern.
Right, that's why we said those three persons could have simply said that whatever was due to us under the award is received by us. So we have no. See, once your claim is satisfied, whether you lease out, sell out, whatever you do, that is a. Direction, what was the direction given there? Arbitral. Parties ಅಂತೂ ಏನಾಗಿರುತ್ತೆ sometimes see, parties may get exhausted in these proceedings. They may receive something and they may walk out. ಅಷ್ಟೇ ಮಾಡ್ತೀವಿ ಅಂತಂದ್ರೆ ಮುಗಿದೋಗುತ್ತೆ ಅಲ್ಲಿ. ಮತ್ತೆ ಅಷ್ಟೇ ಒಂದು ಮೆಮೊ ಹಾಕಿದ್ರೆ ಮುಗಿದೋಗಿರೋದಲ್ಲ. 26 award. Developer shall get the occupied portion of the building vacated. Shall demolish the construction made in contravention of the modified plan. Shall bring it in conformity with the said modified plan. Shall obtain occupancy certificate and deliver to the landowners. Portion falling to the share of the state landowners 1 to 4. In terms of MOU dated 30/12/2009. Rest of it is payment. Something is going on outside. Since. Court litigation ಅಲ್ಲಿ parties ಒಂದೊಂದ್ಸರಿ ಹೇಗಾಗ್ಬಿಡ್ತಾರೆ ಅಂತ whatever it is, we can continue. They will report for us. ಅಲ್ಲ ನಮ್ಮ ಕ್ಯಾಂಪಸ್ ಅಲ್ಲೇ ನಮ್ಮ ಕ್ಯಾಂಪಸ್ ಆಯ್ತು.
ಯಾವಾಗಲೂ ಕಂಪ್ಲೇ ಮಾಡ್ತಾರೆ. He has not done anything. He doesn't do it. Now I will. The award is done. And as corporation to do it, then he will come up in the plea. I have that I can take possession and enjoy it as state I have taken it on me. I will not be able to enjoy the award. Legal structure cannot be subject matter of compromise. Yes, sir, legal subject they can incorporate in a compromise. Even under Article 23, what is not subject matter of dispute or can be incorporated. Not some moral, legal, and those items which are opposed to social value can be part of a compromise.
They have not mentioned in the joint memo that this is subject to the final, this compromise petition is subject to the final result of this case? No, now as he said, the award is, it says that some unauthorized structure should be pulled out. No, as he said, tomorrow his apprehension is, they may go to the authorities and say that the court has recorded the compromise, this is our portion of the property, you cannot pull it down.
Statement says, we here, that we confirm that building is authorized or not, and not taking any position. Or if you not by allowed to compromise the people, facing the lordship. On whether the building is proper or not, that is not part of any settlement parties that saying that as ignorant on record. And then dispute of terms thereof. That's all. So far as parties are concerned.
His submission was that to record that it should be legal. Now there is some unauthorized structure. By recording, this court cannot record the compromise to regularize that unauthorized structure.
It is to regularize, this is not to regularize. Lots of it is not extended from regularization. Now, this can't be that you want to defeat someone else's right and you raise all these. Then you should not record this compromise. So far as my current is concerned, so long as it does not affect his right to challenge or support your report, he can't have any other role to play. His right is, I want this article to appear. I don't know if it will appear or not. Suppose you want to set aside your word tomorrow. Any reason. Then you know there is no asking what he has. We also do not have an article. We have the benefit of.
So one simple sentence is that your claim under the arbitral award is satisfied. ಅಷ್ಟು ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ ಇಷ್ಟೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಬೇಕಾಗಿರ್ ಇಷ್ಟೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್
Because other than parties are ready to sell the property, some parties are ready to lease the property. There were all these discussions that happened at one point in time. So in some way, not possibly they want to settle all the discussions. That's how it happened. Many even notwithstanding all of this. My respect is sufficient so far as we are concerned. If I refer to this, I will accept them from the of the victim. I am consenting to the party who is present that we have no objection to those two paragraphs being pleaded with the compromise petition, as well as the prayer which says set aside the order or the right article. All of that is. Only one not that we have recorded our satisfactory out.
Yes. ಲಾಸ್ಟ್ ಟೈಮ್ ಇದನ್ನೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಿರಲ್ವಾ? ನೀವು ಇದನ್ನೆಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಿರಿ ಆರ್ಡರ್ 23 ಬಾರ್ಸ್ ರೆಕಾರ್ಡಿಂಗ್. ಅಲ್ಲ, he didn't argue anything on those points. Last time, we have noted Order 23 Rule 3 explanation bars regarding such compromise. You have argued that. Explain. Right.
ಅದ್ಮೇಲೆ ಅವಾರ್ಡ್ ಡಿಗ್ರಿ ಆರ್ಡರ್ ಆಗುತ್ತೆ ಅದಕ್ಕೆ when it is proved to the satisfaction of the court it is not simple whatever they want they can do first line ಅಲ್ಲಿ ಹೇಳೋದು when it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part by any lawful agreement on what has been satisfied regarding the lawful agreement being made between the reporting party or compromise in writing and signed by the party or where the defendant satisfies the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order for such agreement. This is not the court. At what time let us find by the party outside. And it is there before the court.
Correct. See, who can dispute this proportion? To record a compromise, it should be lawful. And it is there. ಆಯ್ತು ಹೇಳಿದ್ರಲ್ಲ ನೀವು ಈಗ ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್ ಹೋಗಿ. We have recorded that according to it's not lawful because it is against this. There are some violations.
Again, submission on the last date of hearing was to dismiss the appeal file part made by the arbitrator as upon by the judge in dispute. In the fact that there are no legally another grounds provided under the old or amended arbitral arbitration act. That has reduced further reduced the growth of the act. Despite the act saying that it is prospective, the Honorable Supreme Court of India, while dealing with the dispute between Sangam Engineering and National Railway Authority, that for more proceedings which are in the pipeline, one of this kind. No, it is in pipeline. What had protected the world act? You act there.
Is that judgment?
But that is reported in. That's the one that made the decision. Application of the new act. Second, entire legislation including the assumption for
Para 31.
21. Even the fact that the amended act will now apply. Before to the class 3 and class 4 here. I think apply and bring in the
Okay. Page number ilva ಅದಕ್ಕೆ 31. It is useful. 27. There are many para 30 ಅಂತ ಕಾಣಿಸುತ್ತೆ. Given the fact that amended ಅಂತ ಹೆಸರು ಹೋಗೋಣ. ಅದೆಲ್ಲ ಕೆಳಗೆ ಪೇಜ್ ನಂಬರ್ ಬರ್ತಿರುತ್ತೆ, ನಿಮ್ ಪ್ರಿಂಟ್ ತೆಗಿಯೋದ್ರಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತ ಕಳ್ಸಿ. ಪ್ಯಾರಾ 31. ಎಸ್ ಗಿವನ್. ಆಯ್ತು ಹೇಳಿ ನಾವು. ಎಸ್
No area of the award and the paragraph of the award is shown to be verbal, illegal, or forcefully, partial parity, complete parity, and the expression of the defendant. Otherwise, award. Legal.
So all the parties are residing separate, outside India, or any of them are here? All the respond who are here, 1 and 4, your parties are here. Yaar, who you represent respond number 1 and 4, whether they reside in India or outside. ಅಲ್ಲಿ ಈಗ ಹೋಗಿರೋದಲ್ಲ ಪರ್ಮನೆಂಟ್ ರೆಸಿಡೆನ್ಸ್, ದೇ ಆರ್ ಪರ್ಮನೆಂಟ್ಲಿ ರಿಸೈಡಿಂಗ್ ಔಟ್ ಆಫ್ ಇಂಡಿಯಾ. R4 ಅಲ್ಲಿ R3 and R4 outside. Yes, reply.
Looking at the question about the illegality of the building that my girlfriend referred to. What with great respect is already covered in paragraph 15 of the arbitral award itself. If one
Yes, 111. Yes.
I has made much of the fact of the status of the landowners, their parentage, etc. As if to say that they would never condone any illegal actions on the part of anyone. Unfortunately, the honorable arbitrator has come to slightly different conclusion. At 15, in my opinion, there is a clear acquiescence on the part of the landowners in whatever has happened. As early as in November 2007, in Exhibit C6, the developer told the landowners that it was conscious decision on the part of both developer and landowners to include second basement and to regularize the same upon completion of the project. At the time this was written, only single basement had been provided for in the sanction plan. With the same communication, developer endorsed the benefit of landowners for sanction plan as well as built their plan along with the area statement. Then the developer tells the landowners as per exhibit C6A to the effect that to achieve more area, the developer and the landowners have to collectively decide on the risk of one more floor without sanction, in which case they cannot expect occupancy certificates. He also told the landowners that since the structure is designed to take additional floors, the landowners may likely have their views and comments on this. They have applied the communication, emphasizing the important thing was to take the decision upon the unit at that stage itself, for which that consensus was necessary. Landowners were not harmful on their insisting in more than one clause of the ADA, but really required the district according to the sanction plan. That's required that the social receipts communication exhibit 2007. Was to tell the area strongly disapproving any construction conflict with the sanction plan. And thus, this was totally restricting themselves from any move on the part of the developer to intelligent in illegal construction. Not an iota of material is created from the idea of the landowners to show that any such I was said. To this, added to the 30th November 2009, as per exhibit C11, in pursuit of the clause 5.3 of the JDA, the landowners and the developer following existed a memorandum of understanding specifying liability that is as per clause 5.3 of the JDA and a further specifying the area in each of the first, second, and third floors taken by the landowners towards their share along with 17 car parks and the area in the ground floor along with 4th, 5th, and 6th floor and steel structure again 17 car parks that the developer would take to the share. As 5.2 of the JDA stipulated that within 30 days of the date of commencement certificate, the landowners and the developer should sell it. I don't think it's correct, I think it should be made on the wrong. A demarcated writing with a sanction plan with their respective shares and areas of the said building, which shall be binding on the landowners and developers. It is in pursuit of this clause that the said exhibit C11 was prepared on 30th December 2009. The said clause 5.3 he conspicuously mentioned in the said MOU also. By this, a total of 17,180 square feet was taken by the landowners. Today, my learned friends, is para 6, para 7 of the joint memo. Where do we get these figures from? Where did the 17,180, 17,390 come? It comes from the arbitral award. As your lordships are well aware, your lordships will not interfere with findings of fact in an arbitral award. If the learned arbitrator has taken a view based on material or record, under 34, the appeal court would not take a different view. That is the interpretation. So my respect is sufficient. We can understand it back. 17,000 square feet is taken by the landowners, while the developer takes 17,390 square feet. In addition to each one taking 17 car parks area, excluding the car park area, the total extent shared by landowner and developers will thus come to 34,570 square feet. By then, the modified plan has already been obtained. The relevant clause named was based on these respect. The selection and demarcation of 18 also respective sharing to reference to the plan. The landowners and the developer there agreed to existence of the MOU dated 2009, but expected to have the modified sanction plan on July 2009 before them, with reference to which only the demarcation has been done. The modified plan was for a total extent of 29,459 square feet. It was not difficult for the landowners to realize that while it was their percent share, they could have gotten 15,729.5 square feet out of the sanctioned area of 29,259 square feet, they were under this MOU at Exhibit C11, becoming a party to getting towards their share, more than 2,000 square feet than what they were in. They were finding a fact. Checkwork was required on their part to protest at that time, saying that while they were entitled to 14,729.5 square feet, they would not be made parties to the illegal construction by allotting to their share 17,180 square feet, as against 14,729.5 square feet. Still not an iota of material is based on record, which show that there was the slightest protest on the part of the landowners to this sharing of the illegal construction. Thus, though there was no express communication to the landowners to the developer authorizing him to undertake the illegal construction, their conduct throughout would show that they acquiesced in the other said process. Though on the other aspect, namely, the illegal occupation of the park including building for the developer, without even underlying the occupancy certificate, also being acquiesced by one of the claims that's being present that they have cannot do function. That is hardly evidence. Not the arbitrators pretty much sunk the nail in the bottom of R1 and R4's argument that they had nothing to do with this illegal construction. It seems to be the substantial argument as far as the legality of the building is concerned. What needs to be done as far as the building is concerned? The honorable arbitrator in the first portion of the award is dealt with it. It's a matter for the argument which we have already submitted last year in date that this was an act which is impossible of being monitored by the school people. This was an act which was acquiesced by the claimants before the honorable arbitrator. Therefore, under section 41, that acquiescence should have been taken note of, and they should not have been given that relief. All those arguments are already advanced. This argument
But arbitrator has not endorsed or ratified this. No. All right. Even if they were acquiescent with this thing, that this court can further ratify it.
Feel that this arbitral award should not be interfered under section 37. My submission is very simple. As of today, your lordship has become aware that appellants and respondents 2, 3, and 5 have settled their disputes. The recorded satisfaction of the arbitral. If my learned friend does an objection to para 6 and 7 of the joint, very today itself, we will strike out those 2 paragraphs, have the parties sign it, the lordship need not take cognizance. If there is any unhappy wording about modifying the article, the lordship simply have to say that this honorable court has no jurisdiction to modify an article. However, the joint memo records that respondents 2, 3, and 5 have accorded satisfaction of the award insofar as the monetary compensation, which is the 2 remaining reliefs granted by the honorable. And they do not wish to participate in the execution of the rest of the award. Respondents 1 and 4 choose to execute the award if the lordships uphold it. That is the respondents 1 and 4. As a matter of fact, mention of the last year we gave, the lordship say that insofar as appellants and respondents are 3 and 5 are concerned, they have settled the matter between themselves insofar as satisfaction of their claims under the arbitral. Satisfaction of their claims also means what? Any party can say, I do not wish to execute a judgment in my favor, doesn't make it illegal. I have a judgment in my favor. I can say, I do not wish to execute the judgment, leave me out of it. There's nothing illegal about it. So, in effect, all we are saying is, even if it was a question of an illegal thing requiring to be demolished, etc., I do not wish to execute the judgment, let the law take its course. Anybody else who is interested in the judgment for award can take their own whatever process according to law. So essentially, as far as R 2, 3, and 5 and the appellants are concerned, the award is satisfied. About your joint. So far as 1 and 4 are concerned, it is up to your lordship, based on the submissions of myself appearing to the appellants and the learning council appearing to this. Whether your lordship should uphold the arbitral award. I just also want to find out your lordship. The response numbers 1 and 4 today. It's not as simple as it seems. I already pointed out the lordships that I find that for 5 to 10,000, 6 to 10, 2013.
What is that you have filed?
6 to 10, 2013.
What is that you have filed?
And I also last time given an extra copy of the 6 to 10, 2013.
6/10/2013.
6 to 10, 2013.
What is that you have for this?
A memo under which I had paid the amounts to R1 and 2 person quarter date 11/9/2013 paid by the Senate. 2023. I also submitted extra copies because apparently the earlier number 5 value was untraced.
You say you have given to R1 and 4 also. You say you have given to R1 and 4 also.
Yes. Copy of the memo. Memo of the other slightly memo of the others to deposit of amounts paid as follows 1 and 4.
Is it recorded in the order sheet? 2013. This is appeal of appeal of 2013.
6 and 2023. I've got an example. 6 and 2023.
510. 510. Memo for deposit of amounts. That is 5/10/2023. Banker's check number so and so. It starts as banker's check number so and so issued by SBI Residency Road branch for rupees 2 crores 57 lakhs, etc. Being the share of amount payable to respond number 1. Is it like that? On the 2 crore 57 lakhs and not 1 crore 28 lakhs 57 lakhs.
Second portion of it, the appellants are filing their copies of. The second portion. Appellants are filing their copies of.
But in compliance with the order dated 11/9/2023 passed in the above case, appellants are depositing herewith.
Yes.
Stay. Here check. ಇವ್ರಿರ್ಲಿಲ್ಲ ಯಾರು ಕೊಟ್ಟಿದ್ರು ಅಲ್ಲ ಅವ್ರು ಸೇಮ್ ಇದ್ರಲ್ಲಿ ಹಾಕಿದೀನಿ ಅಂತ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ನಮಗಲ್ಲ ಶೋಸ್ ಯುವರ್ ಎಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ we have only one 5/10/2023. ಅದೇನೋ ಕರೆಕ್ಟ್ ಇರ್ಲಿಲ್ಲ ಅಂತ ರಿಟರ್ನ್ ಕೊಟ್ವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ನೋಡ್ಬಿಟ್ಟು ಕೊಡ್ತೀನಿ.
ಇದು ಸೇಮ್ ಥಿಂಗ್ ಇದು 5/10 ಅಲ್ಲ.
One is a memo just depositing the checks. The second is a memo stating on what basis those checks were issued.
ಇದು ಇಷ್ಟೇ ಇದೆ, ಇದ್ರಲ್ಲಿ ಏನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ವಲ್ಲ. Was the enclosure to that memo? It's continuation of that memo. Like, is there another index of 6 pages? Is it the same index of 6
I
documents?
want your lordship to see those emails.
Correct. ಅದು ನಮ್ಮ ಹತ್ರ ಇಲ್ವಲ್ಲ ಅದು.
That was also filed with the.
We have 510 memos.
That is true of those same day.
Same data.
One immediately the periodic copies.
ಬಹುಶಃ ಅಲ್ಲ ಹೋಗಿದ್ರು ನೋಡಿ, ಅಲ್ಲೇನಾದ್ರು ಹೋಗಿರ್ತ ಅಕೌಂಟ್ಸ್.
I have already. Comply ಮಾಡ್ತಿದ್ದೀನಿ ಅಂತ part of the money they have deposited. They have not paid. What directed?
ಓ ಇಲ್ಲೇನೋ ಒಂದು ತಡಿ ನೋಡೋಣ. 610 ಇದ್ರಲ್ಲಿ ಅದರಲ್ಲಿ ಇಲ್ಲಿದೆ ಬನ್ನಿ. ಕೋರ್ಟ್ ಆಫ್ ಸರ್ ಇದು ಆ ಫೈಲ್ ಅಲ್ಲಿ ಇಲ್ಲ. ನೀವೇನೋ ಇದು ನೋಟ್ಸ್ ಹಾಕಿರೋ ಫೈಲ್ ಅಲ್ಲ. ಸಾರಿ, ದಟ್ ವಾಸ್ ನಾಟ್ ಇನ್ ದ ರೆಗ್ಯುಲರ್ ಫೈಲ್. ಇಲ್ಲಿ ನಮ್ ನೋಟ್ಸ್ ಹಾಕಿರೋನು ನೋಟ್ಸ್ ಹಾಕಿರ್ತಾರಲ್ಲ ಆ ಫೈಲ್. ಬಿಕಾಸ್ ವಿ ಹ್ಯಾಡ್ ಪುಲ್ಡ್ ದ ನೋಟ್ಸ್ ಸಪರೇಟ್ಲಿ ವಿ ಡಿಡ್ಂಟ್ ನೋಟಿಸ್. ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಹಾಕಿಟ್ಟಿದ್ದಾರೆ, ನೋಟ್ಸ್ ಹಾಕಿರೋದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಎಸ್, ವಾಟ್ ಯು ವಾಂಟ್ ಟು ಶೋ ಅಸ್ ಫ್ರಮ್ ದಿಸ್? ಅವ್ರ ಕಾಪಿ ಕೊಡ್ಬೇಕಂತ ಕೊಡಿ, ರಿಟರ್ನ್. ನಮಗೇನು ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ. ಎಸ್ ಹೇಳಿ, ಹೌ ಇಸ್ ಇಟ್ ರೆಲೆವೆಂಟ್?
Further acquiescence, post arbitral. Further acquiescence is made. Stop at everything and they say that everything is
Right, what do you want to? Correct, ಏನು ವಾಟ್ ಯು ವಾಂಟ್ ಟು? ನಮ್ಮ ಹತ್ರ ಇದೆ, ಹೇಳಿ ವಾಟ್ ಯು ವಾಂಟ್ ಟು ಶೋ ಅಸ್. ನೀವ್ ಏನು ಅಂದ್ರೆ ನಿಮ್ಮ ತಲೆಯಲ್ಲಿ ಒಂದ್ ಏನಿರುತ್ತೆ, ಅಥವಾ ಅವ್ರನ್ನ ಹೇಗೆ ನೀವು ಕೌಂಟರ್ ಮಾಡ್ಬೇಕು, ನಿಮ್ಮನ್ನ ಹೇಗೆ ಅವ್ರ ಕೌಂಟರ್ ಮಾಡ್ಬೇಕು, ಕೇಸ್ ಹೇಗೆ ರಿಸಾಲ್ವ್ ಮಾಡ್ಬೇಕು ಅಂತಲ್ಲ. ಎಸ್, ದೇರ್ ಇಸ್ ಅ ಮಿಸ್ಟೇಕ್ ಆನ್ ದ ಪಾರ್ಟ್ ಆಫ್ ಅವರ್ ಹಿಸ್ಟ್ರಿ. ಅದನ್ನ ರೆಕಾರ್ಡ್ಸ್ ಇಂದ ತಗೊಂಡ್ ಬಂದು ಈ ನೋಟ್ಸ್ ಹಾಕೋ ಇದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ನೌ ವಿ ಗಾಟ್ ಇಟ್, ಯು ಪ್ರೊಸೀಡ್.
Page 7. Page 7. Further acquiescence of one other. The requirements 1 and 4 to the entirety of the award. 17th or 15th of July itself. So and so. This is your lordship sees the signature. Another than respondent number 1. Regarding our differences about sale consideration for my MOU area of 5,042 square feet, I discussed the matter with my sons. They are of the view that this matter should be closed. In view of this, I meet the needs of my sisters, so and so, that is respondent number 4. And to confirm the secret to my valuation of my share, I accept your sale consideration of rupees 8,59 lakhs and compensation of 57 lakh 14,087. So this 257 14,087 is deposited below the solidity. First, you are now working on a consolidated price and now look forward to the draft sale deal. The very same property which my learned friend today says illegal, we cannot transact. He can transact. I should not transact by virtue of a joint memo with 3 other landowners. Next page. This page 8. This email will none other than responding number 4. It starts at the big bottom. In the middle, here is so and so, that is responding number. There's a salutation. Further, starts at the bottom. Further to that, email dated so and so, I request clarity of the compensation issue. Can I request page 9?
Yes.
Can I request you to please confirm that the sale amount of 4,29,45,000 excludes compensation of 1,28,57,143, and this compensation amount will be given additionally. The reply is the previous page, because what happens is mails they start from top, the latest to the on 26 June 2023, so and so, in response to a mail when the same consideration payable is more than 0 and the compensation is 128, 57, 143. We hope this clarifies the matter. Now, I need a reply from another than responding before. Citation. Thank you for your email which clarified the query and confirm the same present compensation payable to me. What more is required? All five respondents are giving up
Where-
50%.
Correct. Where is the need to refer to this?
No,
See,
because-
now you pointed out from the award itself that the arbitrator held that they were acquised with this. Then why you refer to?
Most award also there is accusation.
Correct. Why do you refer to
This
this?
is the context of the joint amendment. Can I learn it today?
But still the arbitrator, despite saying that both of you were at consensus, ordered to pull down the building.
But no, can I learn it check with the joint amendment? Saying that they will not participate in illegality, the virtue of the joint amendment.
So two wrongs will make one right, according to you.
No, I don't say that.
Then
When they were ready to sell their share of the building to me and take money for it.
we should.
They cannot go out and go.
No, but even if both of you agree, whether we can put our seal to that.
That is why I mentioned the lordship. Simple solution and also.
Simple is file a memo that the award with regard to your claim is satisfied.
Right now, only 6 and 7 can be struck off, we will get the parties to sign it.
ನಾವು ಪುನಃ ಈ ರಿಪೇರಿ ಕೆಲಸ ಮಾಡೋದಿಲ್ಲ. If you want to file a memo, you file a memo saying that your claim is under the award is satisfied, you have no more claim further, right? That closes the matter. Because if parties have something else, I mean tomorrow there should not be any dispute among themselves. Those admissions will be there on record here. Correct. That's
Area. Parties agree. This government will not even otherwise, let's say there's no building plan. And two parties said she will divide the area into each level. Subsequently, got to Excel instruction. This is PDMP plan to ultimately say as to how, what, where, and when revolution takes place or removal takes place. The removal may result in a significant 5.1 million. It is not as if no one we do not know as to what has been done to bring it in one of the sanction plan. Because arbitrator has not said it. How much of the arbitrator does not have to see it either. To say which portion is removed, how it has been. That is not part of the duty of the arbitrator. Arbitrator has said in this case, of course, there is some extra construction, you must bring it down. Now, bringing it down not ultimately goes subject to law. Like when I do for example, suppose a scheme becomes applicable. And another scheme will enter into them. Whatever so much thing I need to exercise. Upon payment of certain sum. This is why it is not simply not.
correct. You want us to record only this compromise petition.
That's all.
As a letter to find out, I will file a memo, find all the. The paragraph 5 and 6 of the joint document. And it is a clear question
Not only 5 and 6, he referred to para 2, 3, 5.
Correction in the light of the subsequent submissions made by the learned may not be necessarily over that. Appellants in R2, 3, and 5, it's included by a joint member. Saying that appellants 2, 3, and 5 record satisfaction to the relief granted to them under the act.
That's what we said. No, but he has to take instruction. If they say that their claim under the award is satisfied, they have no further claim, then that ends the matter. So whatever is between them, then that we have to record only. I mean, we have to adjudicate only on the issues between the appellant and response 1 and 4. So now arguments on merits is over. Yes. Okay, now today you are going to file a memo or? We'll pass it on. Let's be, we'll list it tomorrow if you want. Tomorrow you.
In terms of joint member cases.
ಅಲ್ಲ ನೋಡೋಣ ನೀವ್ ಹೇಳಿದ್ದನ್ನೇ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ ಅವ್ರ ಕ್ಲೈಮ್ ಸ್ಯಾಟಿಸ್ಫೈ ಆಗಿದೆ ಅಂತ their apprehension will be how much amount they have received to settle. ಮಾಡಿ ಹಾಕಿ ಸುಮ್ಮನೆ ಇದು next we can decide on merit so far as appellant and respond number 1 and 4, and you can withdraw this memo. Then we'll score that. ಅಲ್ಲ ಅದೇನ್ ಬರ್ದಿದ್ಯೋ ಈಗ ಏನೇನ್ ಬರ್ದಿದ್ವೋ ಅದನ್ನೆಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. Will not record that. ಅಲ್ಲ because we had already given dictation, ಅದು ಬಿಟ್ಬಿಡ್ತೀವಿ. ಎಲ್ಲ ಬಿಟ್ಬಿಡಿ. You are making to do us lots of exercises.
Presence of the parties may be recorded. Execution of joint memo may be recorded. Whether the lordships are.
Then we will say that there are some defects in the memo, they will rectify that ಅಂತ ಹೇಳ್ತೀವಿ. ಹಾಗೆ ಮಾಡ್ತೀವಿ. ಅದೆಲ್ಲ ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ವಿ ಆಗ್ಲೇನೆ. we had recorded 2, 3, 5 ಅದೆಲ್ಲ ಇತ್ತು. That will correct only that. We had already recorded that. We have a meeting at 5:15. The parties are going to stay tomorrow also, no? Or you can. ಆಯ್ತು ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ ಮಾಡಿ within 30 minutes. ಅದು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದು ಹಾಗೆ ಇರಲಿ, ಅದ್ರ ಮುಂದೆ ನಾವು ಎಸ್ ಇದನ್ನು ಅದ್ರಲ್ಲಿ ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ಮುಂದೆ ಹಾಕಿದ್ವಲ್ಲ 31, 32,
32.
ಇದ್ರಲ್ಲಿ ಏನೋ ಕೃಷ್ಣಸ್ವಾಮಿ ಏನು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರ ಫರ್ದರ್ ಅದರ್ಸ್ ಮ್ಯಾಟರ್ಸ್ ಮೇ ನಾಟ್ ರೀಚ್. ಬೇರೆ ಅವ್ರು ವೇಟ್ ಮಾಡೋದು ಬೇಡ. ಯಾಕಂದ್ರೆ 33 ಅಂತೂ ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿರೋ 33 ಇದಾವ್ರು. ಇವ್ನು ಕರೆಸ್ಬಿಡಿ ಲಿಸ್ಟ್ ನಂಬರ್ 2. ಆಲ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2. ಡಿಸ್ಕಷನ್ ಆದ್ಮೇಲೆ ಮಾಡೋಣ ಬಿಡಿ ಎಲ್ಲ. ಒಂದೊಂದಾಗಿ ಕರಿತಾ ಹೋಗ್ಬೋದು. ವೇಟ್ you are for the appellant, no representation for the appellant as child. Yes. 2.
Number 2, Krishnamurti D.
Right. ಇದೇನು ಅರ್ಜೆಂಟ್ ಇತ್ತ? Was it urgent? ಯಾಕೆ ರಿಲೀಸ್ ಆಗಿಲ್ಲ ಅಮೌಂಟ್? List in the next week. Next week. FC na ಇದು? As requested by response counsel. Adjourned at the request of response counsel. Yes, next.
Number 4, Shivaprasad E. Shashidhar R.
Urgent. Date ಕೊಡೋದಿಲ್ಲ ಎಲ್ಲ after vacation ಬರುತ್ತೆ ಅಷ್ಟೇ. Not possible. After vacation ಹೇಳಿ ಆಗ.
3-1.
ಯಾವ್ದದು? 3 ಅಲ್ಲ, serial number 3. As requested by response counsel, list on 3-1. Yes.
Number 4, Shivaprasad R. Shashidhar.
Shashidhar ಏನು ಅರ್ಜೆಂಟ್ ಇತ್ತ ಇದ್ರಲ್ಲಿ ಏನ ಆನ್ ಫೈಲಿಂಗ್ ಆಫ್ ವಕಾಲತ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R1 and R2 ನೀವೇ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. Urgent at request of response counsel.
Number 6, Sharad Gowda GB.
Party shall be present before the court ಅಂತ ಆಗಿದೆ. ಅದೇ ಇವ್ರದ್ದು ಇಲ್ಲೇ ಬೆಂಗಳೂರು ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಕಳ್ಸಿದ್ದು ಆ ಕೇಸ್ ರೆಫರ್ ಮಾಡೋದು ಬೇರೆ ಅದೇ ಬೆಳಿಗ್ಗೆನೆ ಹೇಳಿದ್ರೆ ಬೆಳಿಗ್ಗೆನೆ ಕಳಿಸ್ತಿದ್ವಲ್ಲ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಮೀಡಿಯೇಷನ್ ಕಳ್ಸೋದಕ್ಕೆ ಅಂತ ಹೇಳಿದೆ ಮಾಡಿದ್ರ ಯು ಕುಡ್ ಹ್ಯಾವ್ ಮೆನ್ಷನ್ ಇನ್ ದ ಫಸ್ಟ್ ಹಾಫ್. ಯಾರು ನಮಗೆ ಹೇಳಿದ್ರ?
130 ಹೇಳಿದ್ರು 230 ಮೆನ್ಷನ್ ಮಾಡಿ.
ಎಲ್ಲಿದ್ದಾರೆ? This is child custody matter. There is delays also. There is an element of settlement. Therefore, party shall appear. ಒಬ್ಬರೇ ಬಂದಿದ್ದಾರಾ? Who represents respondent? Sharad Gowda is for petitioner. Appellant, for the appellant. ಅಲ್ಲ ನೀವು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು ಇಲ್ವಾ? ಅವ್ರು ನೋಡಿ 53 years 49 years ಇದ್ದವರೆಲ್ಲ ಇದ್ದಾರೆ. ಬೆಳಿಗ್ಗೆ 1:30 ಇದ್ರ ಲೇಟ್ ಆಗಿ ಬಂದಿದ್ರಿ ಏನ್ ಮಾಡಿದ್ರಿ? ಏನಂತ ಡಿಸ್ಕಷನ್ ಅಲ್ಲಿ ಏನ್ ಬಂತು? ವೆದರ್ ದೇ ಆರ್ ರೆಡಿ ಟು ಗೋ. ಇದು ಏನೋ ಗ್ರ್ಯಾಂಡ್ ಪೇರೆಂಟ್ಸ್ ದೇ ಆರ್ daughter is no more. Is it a case of natural death or unnatural death? Child is in his custody. He has remarried. How old is the child? 4 years. ಇನ್ನೊಂದು ದಿವಸ ಅಪಿಯರೆನ್ಸ್ ಮಾಡ್ಬೇಕು, ಇಲ್ಲ ಅಂತಂದ್ರೆ ಮತ್ತೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ದೇರ್ ಪಿಟಿಷನ್ ಇಸ್ ಡಿಸ್ಮಿಸ್ಡ್. ಇನ್ನೇ ಅಲ್ಲ ನಿಮ್ ಕೇಸ್ ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಹೇಳಿದ್ರಿ ಮೀನ್ ಇಫ್ ಗ್ರ್ಯಾಂಡ್ ಪೇರೆಂಟ್ಸ್ ಆರ್ ನಾಟ್ ದೇರ್ ದೆನ್ ದೇರ್ ವಿಲ್ ಬಿ ನೋಬಡಿ ಟು ಟೇಕ್ ಕೇರ್ ಆಫ್ ಅಂತ ಯಾರು ಹೇಳ್ತೀವಿ? ನಿಮ್ ಕೇಸ ಬೇರೆ ಕೇಸ್ ಅಲ್ಲ. ದೇ ಆರ್ ಸಾಟ್ ಕಸ್ಟಡಿ ಹಿಯರ್. This child, through this child, they filed this. They claim to be the next friend of the child in the suit. ಏನ್ ಅವ್ರ ಇಲ್ಲ ಅಂತ ಬರ್ಕೋಬೇಕಾಗುತ್ತೆ ನಾವು ಅಷ್ಟೇ. ನಿಮಗೆ ಇನ್ನೇನ್ ಮಾಡೋದು? ನಾವೇ ಕನ್ಸಿಲಿಯೇಷನ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ವಾ? ಮಗುನ್ ಕರ್ಕೊಂಡ್ ಬಂದಿದ್ರಾ? ಇಲ್ಲ. Serial number 6. No representation of the appellant. Respondent and his counsel are present. ಏನ್ ಮಾಡಿದೀವಿ? ಇನ್ನೊಂದ್ ದಿವಸ ಇಲ್ಲೇ ಬರೋದಕ್ಕ ಏನೋ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕೋಣ? ಅವ್ರಿಗೆ ಬಂದ್ರೆ ಪಾರ್ಟೀಸ್ ಬಂದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು. ಇಲ್ಲ 1:30 to 2:30 ನಮ್ಗೆ ಇರೋದು ಟೈಮ್. ಅವಾಗ ಮಾಡಿದ್ರೆ ಮಾಡ್ಬೇಕು. ಅದ್ಯಾಕೆ ಮೀಡಿಯೇಷನ್ಗೆ ಯಾಕೆ ಹೋಗಿ ಬರ್ಬಾರ್ದು? ವೈ ಬಿಫೋರ್ ಅಸ್ ಓನ್ಲಿ? ಕೋರ್ಟ್ ಮುಂದೆನೆ ಆಗ್ಬೇಕು ಅಂತನಾ? ರೈಟ್. The party shall be present before the court on the next hearing date. List on 13th. ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿ. ಯಾರು ಏಜ್ಡ್ ಪರ್ಸನ್ಸ್ ಇದ್ದಂಗಿದ್ದಾರೆ ಆಯ್ತು.
ಬೈರೇಗೌಡ ಟಿ ನಾಗರೆಡ್ಡಿ
ಸಿಬಲ್ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ಅಪೆಲೆಂಟ್ who is read, appellant or respondent? Statement of LS of number 13 and R21 who has filed IA3 of 2023 or sale and represent ಇಲ್ಲ ಆಮೇಲೆ ನೋಡೋಣ ಇದನ್ನೆಲ್ಲಿ ಇರೋ ಟೈಮಲ್ಲಿ ನೋಡ್ಕೊಂತಿರ್ತೀವಿ. ಬಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಅಪ್ ಅನದರ್ ಮ್ಯಾಟ್ರ್. ಇನ್ನೊಂದು ದಿವಸ ಹಾಕೊಳ್ಳೋಣ ಬೇಕಂದ್ರೆ ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ಸ್ ಮಾಡೋದಕ್ಕೆ. ವಿ ಹ್ಯಾವ್ ಟು ಎಕ್ಸಾಮಿನ್ ದ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ವಾ? ಏನು IA 1 of 2023 ಅಲ್ಲಿ ಇನ್ನೊಂದೇನೋ ಅಲ್ಲೊಂದೇನೋ ರಿಕಾಲಿಂಗ್ ದ ಆರ್ಡರ್ ಡೇಟೆಡ್ ಅಂತೇನೋ ಒಂದು 5/10/2023 ಸ್ಟೆಪ್ ಟು ಬಿ ಟೇಕನ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಪ್ರಪೋಸ್ಡ್ RA 18A. ಈ ವ್ಯಾಖ್ಯೆ ಇದು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬರ್ಬೇಕಾಗಿತ್ತಲ್ಲ, ಇಲ್ಲ ಕೊಟ್ಟು 7.1 ಅದರಲ್ಲ ಲಿಸ್ಟ್ ಇಸ್ ಮ್ಯಾಟರ್ಸ್ ಆನ್. ಆಯ್ತು, ಮುಂದಿನ ವಾರದಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ಆರ್ಡರ್ಸ್ ಇನ್ ಆರ್ಡರ್ಸ್ ಮ್ಯಾಟರ್ಸ್. ಯಾವ್ದೋ ಸೈಡ್ ಇಟ್ಕೊಂಡಿದ್ದೀವಿ. ಸೀರಿಯಲ್
ನಂಬರ್ 8.
ಬಹಳ ಕಷ್ಟ ಇದೆ, ಇವ್ರು ಮಾಡಿರೋದೆಲ್ಲ ಮುಗಿಸ್ಬೇಕು, ಪಾರ್ಟೋಡ್ ಇರೋದೆಲ್ಲ ಮುಗಿಸ್ಬೇಕು. ಅಲ್ಲ ಹೋಪ್ಫುಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ನಮ್ಗೆ ಬರುತ್ತೆ ಬಿಡಿ. Here no representation for respondent. This one after vacation later. If you want. ನೀವೇನ್ ಮಾಡ್ತೀರ ಗೊತ್ತಿಲ್ಲ, ಆದ್ರೆ ಆದಷ್ಟು ನಮಗೆ ಬರ್ತಾನೆ ಕರ್ಸಿ. up to 40% in the on that point alwa. Yes. Again, you showed some judgment also on that point alwa. 2018 ACG last month. So consider ಆಯ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ವಲ್ಲ ನಾವು, ಅವ್ರೇನೋ ಬೇರೆ ತೋರಿಸ್ತೀನಿ ಅಂತ ಹೇಳೋದು. 50% 40% ಅದ್ರ ಮೇಲೆ some percentage of future prospectus reduces. ಅದೇ ಹೇಳಿದಲ್ಲ, in this case charge sheet is filed only against your driver. Complaint is filed. Plaint is presented or appeal memo is presented. What is the ultimate result? Charge sheet is not binding. Not only complaint, the other material. Charge sheet is not binding. Complaint is also not binding. Court has to examine. ಕಂಪ್ಲೇಂಟ್ ಇಲ್ದೇನು ಹಾಕೋಬಹುದು, ಹಾಕ್ಬಾರ್ದು ಅಂತ ಹೇಳಿ. FIR ಇಲ್ದೇನೆ ಕರೆಕ್ಟ್, FIR ಇಲ್ದೇನೆ MEC ರಿಜಿಸ್ಟರ್ ರೂಲ್ 230. ಓಕೆ, ಆದ್ರೆ ಆಕ್ಟ್ ನಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಅಲ್ಲ ಅದು ರೂಲ್ ಅಲ್ಲಿ ಮಾತ್ರ ಮಾಡಿದ್ದಾರೆ. ಆಲ್ವೇಸ್ ನೀವು ಯು ಹ್ಯಾವ್ ಎಕ್ಸಾಮಿನ್ ದ ಡ್ರೈವರ್ ಆಫ್ ಯುವರ್ ವೆಹಿಕಲ್. ಅದೇ ಹಿಮೇಂದ್ರ ACB means ACPN. But he only, last time it appears you read, he only filed the charge sheet. He did not conduct the election. Last time only. He has not recorded the statements of the witnesses that he admitted. Last time, ಓದ್ದಂಗಿತ್ತಲ್ಲ. Yes. According to charge sheet takes precedence over complaint. Last time we said that we'll take up this farm number 15 for 2019. Page number 3. Sarah? Yes, ma'am. Yes. Madam, one is the official of the insurance. Yes. It is their own witness. Look, you can see now last time Krishna Swami ಅವರು ಹೇಳಿದೀವಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಪಾಯಿಂಟ್ ಮೇಲೆ ಎಲ್ಲ ಎವಿಡೆನ್ಸ್ ಓದಿದ್ಮೇಲೆ why do you want to further elaborate? Why do you want to further elaborate on negligence part? ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರಿಗೆ ಹೇಳಿದ್ವಿ ಅವ್ರ ಎಕ್ಸಾಮ್ ಇನ್ನೂ ಮಾಡಿಲ್ಲ ಅಲ್ಲ ಅವರು ಹೀಸ್ ಲರ್ನರ್ ಕೌನ್ಸಿಲ್ he does not seem to be a motor accident claims lawyer. He is a civil lawyer. Civil advocate or ನೀವು civil practitioner. ಅಲ್ಲಲ್ಲ ಅಲ್ಲಿ their own witness has given evidence against them. Charge sheet is filed against them. They took up the contention that the vehicle was in motion. He came from the hindsight and hit him. Again they changed version to parked lorry. Our evidence Premalata Shukla ಅಂತ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅವ್ರದೇ ಎವಿಡೆನ್ಸ್ ಇದ್ರೆ they can't resign from that. RW2 is their own evidence. ಅದು ಬಿಟ್ಟು ಕ್ವಾಂಟಮಿಗೆ ಬನ್ನಿ You can go to the next point about quantum. So last time ನಾವು ಒಂದು ಕೇಳಿದ್ವಿ ಅಲ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ ನಲ್ಲಿ they have taken monthly salary. ನಾವು ಹೇಳಿದ್ವಿ ಅವ್ರದ್ದು ಫಾರ್ಮ್ ನಂಬರ್ 16 ಇದೆ. There is form number 16. Why that income shall not be taken? He this is upper letter. Yes. I know. Date of accident was 5/7/2019. Pay slip of June 2019. Yes. Page number? Yes. Page number, internal page 36. Yes. 810. Yes. Hmm. ಮೃತರ ಕೆಲಸ ಶಾಶ್ವತವಾದ ಕೆಲಸವಾಗಿರಲಿಲ್ಲ ಎಂದ್ರೆ ಸರಿ ಅಂತ ಹೇಳಿದಾರಲ್ಲ. ಇಲ್ಲ ಕರೆಕ್ಟ್. ನಿಮ್ಮ ವಿಟ್ನೆಸ್, he was your witness in the evidence stated 8/10/2021 which you are reading now. The last sentence he says that ಮೃತರ ಕೆಲಸ ಶಾಶ್ವತವಾಗಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಅವರ ಕೆಲಸ ಪ್ರೈವೇಟ್ ಸೆಕ್ಟರ್ ಆಗಿರುತ್ತದೆ. ನಾವು ಎಸ್ ನಮ್ಮ ಹ್ಮ್ You are referring to 9 of? Yes. Citations ಕೊಡ್ತಾ ಇದ್ದಾರೆ ನಿಮ್ಗೆ. Yes. Paraffin. Right. Yeah. Here also I have brought one Kulkarni only. Judgment. 2020. This is from Karnataka only. Twenty-three, 1 second. 22, 9. Where are you reading? 2023. Page number 6. This. Correct. First judgment ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಅದು 23/3/2020. That is the latest one. That covers every point. Why do you want to multiply them? In that case also there was a clause to terminate. That is the latest judgment. Then why do you want to multiply them? Let's see. Yes. Correct. Here also there was a clause in this 2023 judgment which said that they could be terminated with a notice. That's all. But he says Supreme Court says that that indicates the permanent employment. Right. ಕರೆಕ್ಟ್ ಮುಂದಿನ ಬೇಡ ಅಂತ ಅನ್ಸುತ್ತೆ ನಿಮಗೆ ಇಷ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ರಿ ಮುಂದಿನ ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಅದ್ರ ಮೇಲೆ 50%. ವೈ ಡು ಯು ಮಲ್ಟಿಪ್ಲೈ 50% ಅಲ್ಲ ಇವ್ರ ಏಜ್ ಎಷ್ಟಿರುತ್ತೆ ಅದಕ್ಕೆ ನೋಡಿ ತಗೋಬೇಕು. ದಿಸ್ ಇಸ್ ರಿಗಾರ್ಡಿಂಗ್ ನೇಚರ್ ಆಫ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್. ದೀಸ್ ಜಜ್ಮೆಂಟ್ಸ್ ಆರ್ ರಿಗಾರ್ಡಿಂಗ್ ನೇಚರ್ ಆಫ್ That he was submitting this allowance, conveyance allowance, LTC ಇದೆಲ್ಲ ಅದ್ರಲ್ಲಿ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ಅವ್ರು. See, LTC is not the regular salary. Medical allowance, special allowance is 31,190. Another concept, we can go by this income tax return submitted. ಅದನ್ನ ತಗೊಂಡು ಅದ್ರ ಮೇಲೆ ಮಾಡಿದ್ರೆ ಆಗುತ್ತೆ. ಏನ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಇದ್ರು ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಹೇಳಿದಾರೆ 50%, 40%, 35% ಅದನ್ನೇ ಕೊಡೋದು. ಯು ಕ್ಯಾನಾಟ್ ಕನ್ಸಿಡರ್ ದೀಸ್ ಥಿಂಗ್ಸ್. Page 42. Page 42 of his paper, trial court records. ಏನದು ಯಾವ ಎಕ್ಸಿಬಿಟ್? ಎಕ್ಸಿಬಿಟ್ ನಂಬರ್ ಎಷ್ಟು? P14 ಇರಬೇಕು. P14. P14 ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಅದು ಏನಿದ್ರು ದಿಸ್ ಇಸ್ ಆಲ್ ವೇರಿಯೇಬಲ್ ಇರುತ್ತೆ. ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಫಾರ್ಮ್ ನಂಬರ್ 16 ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿದ್ದು ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟು ನಂಬರ್ ಇವರೇ ಅವ್ರು ಮಾಡಿದ್ರು ಅಂತ ನೀವು ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ರಿಲೈ ಆನ್ ಎಕ್ಸಿಬಿಟ್ P16. P16 ಅಲ್ಲ, ಫಾರ್ಮ್ ನಂಬರ್ 16 is exhibit. Form number 16 is exhibit P13. Net income is 13 lakhs. This ಒಂದೇನೆ ನಿಂತಾರೆ. You are referring to trial court judgment, tribunal judgment. Forty-one. हम तಗೊಂಡ್ರೆ Yes. P13. There's a medium there. Or 0, 0. They're not separately. P32, no? P32. P32. Yes, P32. Yes. Yes, here. This is not one minute. Meeting ಅಂದ್ರೆ ಯಾರಾದ್ರೂ he died in between ಅದಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅದಕ್ಕೆ ನಾವು ಇಲ್ಲಿ ಕಾಣಿಸ್ತೀವಿ. Yes. The perks. Yes. Yes. How much time we are going to take for that? Because we have a meeting now. What a response also. In part for further hearing. Yes, sir. What a column. 6. 6, right? ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಮಾಡಿದ್ರೆ ಅಕ್ಕ ಇದೆಯಲ್ಲ ಏನು MFA ಫ್ಯಾಮಿಲಿ ಕೊಡಿಸಿ ಡೇ ಆಫ್ಟರ್ ಎಷ್ಟು 6 ಬೇಡ ಅಂತಾರೆ ಇನ್ನೊಂದು ದಿವಸ ಹಾಕ್ತಾರೆ. ನಾನು ನಾಳೆ ಹಾಕೊಂಡು ರೀಚ್ ಆದ್ರೆ ಆಗುತ್ತೆ ಇಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡಿ we have a meeting also we have to record on tomorrow 2:30 ಅಂತ ಮಾಡಿ
13 ಇದೆ.
ಇನ್ನೊಂದಿದೆಯಾ ಇನ್ನೊಂದಿದೆ ಅಂತಲ್ಲ ನಾಳೆ ಇವ್ರದ್ದೇನಾಯ್ತು ಹ್ಮ್ ಯಾವ ಕೇಸ್ ಅದು ಅದೇ G&W ಮತ್ತೆ ಅವ್ರಿದ್ದ ಕರ್ದಾಗ ನೀವು ಬರ್ಲಿಲ್ಲ ಕರ್ದಾಗ ನಾವ್ ಇಲ್ಲ ಅಂತ ಬರ್ಕೊಂಡ್ಬಿಟ್ವಿ ಯು ಆರ್ ಹಿಯರ್ ಮೀಡಿಯೇಷನ್ ಅಲ್ಲ ಅವ್ರೇನ ನೀವೇ ನಮ್ಮ ಎದುರಿಗೆ ಕನ್ಸಿಲಿಯೇಷನ್ ಆಗ್ಲಿ ಅಂತ ಹೇಳಿದ್ರು ಡೇಟ್ ಕೊಟ್ಟಿದೀವಿ ನೋಡಿ ಹಾಗಾದ್ರೆ ಕರೆಕ್ಟ್ ಸಿ ವಿಸಿಟೇಷನ್ ರೈಟ್ಸ್ ನೀವು ಕೇಳಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಅವರು ಇವಾಗ ನಾವ್ ಯಾವ್ದು ವಿಸಿಟೇಷನ್ ರೈಟ್ ಅಲ್ಲ ನೀವು ಕಸ್ಟಡಿ ಕೇಳಿದ್ರಿ ಯಾವ್ದೊಂದು ಡೇಟ್ ಹೇಳಿದ್ವಿ ಇವತ್ತು 13-12 ಆಸ್ತಿ ಅಂತ ಆಗೋದಿಲ್ಲ ಸಿ ನಾವು ಪ್ಲೀಸ್ ಡೋಂಟ್ ಮೆನ್ಷನ್ 13-12 ಇನ್ನೇನ್ ಜಾಸ್ತಿ ದಿವಸ ಇದೆ 4-12 ಅಲ್ಲ ಇವತ್ತು ಅವ್ರು ನೋಡ್ಬೇಕು ಅಂದ್ರೆ ಕರ್ಕೊಂಡ್ ಬಾ ಅಂತ ಹೇಳ್ರಿ ಅವ್ರಿಗೆ ಯಾರು ಹೂಸ್ ಈಗ ಆಸ್ಟ್ ಟೈಮ್ ಏನ್ ಸ್ಕೂಲ್ಗೆ ಹೋಗುತ್ತಾ ಮಗು ಸ್ಕೂಲ್ಗೆ ಹೋಗುತ್ತಾ ಏನ್ 4 ವರ್ಷಕ್ಕೆ ಯಾವ ಸ್ಕೂಲ್ ಹ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಅವತ್ತೊಂದ್ ದಿವ್ಸ ನೋಡ್ತೀನಿ ಅಂತಾರೆ ನೋಡಿದ್ರೆ ನೋಡ್ಲಿ ಮೈಸೂರಲ್ಲಿ ಮಾಡಿಲ್ಲ ವಿ ಆಸ್ಕ್ ದೆಮ್ ಟು ಅಪಿಯರ್ ಬಿಫೋರ್ ಅಸ್ ಕರೆಕ್ಟ್ ಸಿ ದೇ ಆರ್ ಗ್ರ್ಯಾಂಡ್ ಪೇರೆಂಟ್ಸ್ ನೋಡ್ಬೇಕು ಅಂತಾರೆ ಕರ್ಕೊಂಡ್ ಬಂದು ತೋರಿಸ್ಕೊಂಡು ಹೋದ್ರೆ ಏನಾಗುತ್ತೆ 13th ಆಯ್ತು ನಿಮ್ಗೆ ಬೇಕು ಅಂದ್ರೆ ನೀವು ಇಮಿಡಿಯೇಟ್ಲಿ 11 ಗಂಟೆಗೆ ಕರ್ಕೊಂಡ್ ಬರೋದ್ ಬೇಡ 12:30 ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ನಾವು 1:45 ಇಳಿತೀವಲ್ವಾ ಅದೊಂದು ಅವ್ರು ಕಳ್ಸೋದಕ್ಕೊಂದು ವ್ಯವಸ್ಥೆ ಮಾಡ್ಬೇಕಲ್ಲ ask him to bring at 10:30 or 11 let them meet for some time thereafter we can hold the conciliation after between 1:30 and 2:30 ನೀವೇ ನಿಮ್ ಸೀನಿಯರ್ ಹೇಳಿದ್ರು ಅವಾಗ ಫಾರ್ ಎ ಮ್ಯಾರೇಜ್ ದ ಬಾಯ್ ವಾಸ್ ಸೆಂಟ್ ಅಂತ ಈಗ ಮತ್ ಇವಾಗ ಒಂದ್ ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ಏನಾಗುತ್ತೆ ವಯಸ್ಸು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಭೇಟಿ ಆಗ್ತಾರಲ್ರಿ ಅವರೆಲ್ಲ ಸಿ ವಿ ಆರ್ ಓನ್ಲಿ ಫ್ಯಾಸಿಲಿಟೇಟಿಂಗ್ ಅ ವಿಸಿಟ್ ನಮ್ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇಲ್ಲಿ 11 ಗಂಟೆಗೆ ಬಂದ್ರೆ ಚೇಂಬರ್ ಅಲ್ಲಿ ಹೋಗಿ ಭೇಟಿಯಾಗಿ ಬರ್ತಾರೆ ಅಷ್ಟೇನೆ RHLC ಇರುತ್ತೆ ಅಲ್ಲಿ ಹೋಗಿ ಎಲ್ಲರೂ ಹೋಗಿ ಒಂದ್ ಕಡೆ ಮಾತಾಡ್ಕೊಂಡು ಬರ್ಲಿ ಅಷ್ಟೇ ಎಸ್
ಎಕ್ಸ್ಪೆಕ್ಟೇಷನ್ ಆಗಿತ್ತು
ಎಸ್ ನಾವು ವಿ ಹ್ಯಾವ್ ಅ ಮೀಟಿಂಗ್ at 5 o'clock
ನಂಬರ್ 8
ಅವ್ರು ಯಾರು ಮಾತಾಡ್ತಾರೆ
serial number 8
serious all the matters are urgent except this now which we are taking up now
this but online display board shows me it's 8 sorry
date ತೋರಿಸ್ತಾ ಇದೆ ಬೇರೆ ಕೋರ್ಟಿಂದ ನಮ್ ಕೋರ್ಟಿಂದ ನೋಡಿ 8 ನಮ್ ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ anyway it's urgent all right
please
ಸರಿ ಏನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ನಾವು ಓ ವೈಟ್ ಶೀಟ್ ಮೇಲೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಏನು ಅಪೋನೆಂಟ್ಸ್ ಆಫ್ ಫೈಲ್ ದ ಅಬೌವ್ ಅಪೀಲ್ ಚಾಲೆಂಜಿಂಗ್ What are you going to do for your previous joint work? You are not mentioned here in this. What do you say? ಇದನ್ನ ತಗೋಬಹುದಲ್ಲ ಯಾರ್ಯಾರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಅದ್ ಸೇಮ್ ಥಿಂಗ್ ವಿಲ್ ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಯಾರ್ಯಾರು ವಕಾಲತ್ ಹಾಕಿದ್ರು ಯಾರನ್ನ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ರು 2, 3 and 5 submit that they have entered into a compromise. They are duly identified by their council ಅಂತ ಇತ್ತಲ್ಲ ಇಲ್ಲಿ ಆದ್ಮೇಲೆ response 2, 3 and 5 submit a joint memo signed by the respective councils also. They submit that in view of the present joint memo. Their council submit that in view of the filing of the subsequent joint memo, they withdraw their earlier joint memo dated 8/9/2023. Therefore, the joint memo dated 8/9/2023 is disposed of as withdrawn. Response 2, 3 and 5. Are you still there? What is the understanding here? You are aware of this? You have gone through the contents of this? Who's that? Respond number 2 has agreed to accept rupees 1,28,57,143 in full and final settlement of the amounts payable by the appellants to respond number 2. And I have already received that. Who is respond number 2? What is the name of respond number 2? Fauzia. Yeah, received 1,28,57,143 by banker's check dated 8/9/2023. All right. So I have no claim further. Okay. Respond number 3 is Firdous Ali. Yes. You too have acknowledged the receipt of 1,28,57,143 full settlement of your claim. Respond number 5, Muhammad Irshad. You have received 2,57,14,285 in settlement. ಕಿವಿ ಕೇಳೋದಿಲ್ಲ. Receipt I have. Respond number 5 hereby acknowledges receipt of 1,20,00,000 on 21st March. And appellant 2 has paid balance of 1,37,14,000 etc. by banker's check dated 8/9/2023. So all the three of you are giving up any claim against him. He is the appellant. Who is the appellant? He is the appellant. There are 2 appellants. So again,
same name, appellate one was the partnership firm, subsequently became a company. That is appellate 2.
Oh, there are 2 partners, Syed Mohammed Beri and Abu Bakr Beri.
Yes, both are.
So you are not going to seek any further claim against them. Third response 2, 3, 5 and the council on the joint memo. Parties admit that they have voluntarily executed the same memo and the receipt of the amount as stated in the joint memo. They claim that on accepting the said amount in full settlement of their claim, the arbitral award may be taken as satisfied so far as those respondents. ಏನಾರು ಹೇಳೋದಿತ್ತ ನಿಮ್ಗೆ? Okay, all right. The memo is taken on record. The memo is recorded accordingly. ಅದಾದ್ರೆ ಮಾಡಿಫೈ ಮಾಡೋದು ಹೇಗೆ ಅಂತ ಕೊನೆಗೆ ನೋಡ್ಬೇಕು ಅವ್ರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ. Arguments heard the modification. Only the merits on merits, both of you have already argued alva. ಇನ್ನೊಂದ್ ದಿವಸ ಹಾಕೊಳ್ತೀವಿ ಏನಾದ್ರೂ now in this changed scenario, if you want to file any, There is no scope for interference according to you. Yeah. Yes, ನೀವೇನ್ ಹೇಳಿದ್ರೆ
Maybe just post it for one more hearing, take the argument and merits. Is there any citations or?
ಅದೇನಿಲ್ಲ ನೀವೇನಾರ ಯಾಕಂದ್ರೆ ನಮಗೆ ಈಗ ಡಿಕ್ಟೇಷನ್ ಕೊಡೋದಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ನೀವೇನಾದ್ರೂ ಸಿನಾಪ್ಸಿಸ್ ಇಂದ ಮೀನ್ ಟೈಮ್ ಹಾಕ್ತಾ ಇದ್ರೆ ನೆಕ್ಸ್ಟ್ ಒಂದು ಡೇಟ್ ಇಡ್ತೀವಿ ಅಷ್ಟು. ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಇಟ್ ಇನ್ ಅಡ್ವಾನ್ಸ್ ಸೊ ದಟ್ ವಿ ಕ್ಯಾನ್ ಪ್ರೊಸೀಡ್ ವಿತ್ ದ ಮ್ಯಾಟರ್. So can we say now the appeal in respect of these respondents should disposed of accordingly?
Yes, yes.
The appeal in respect of respond number 2, 3 and 5 should disposed of in terms of the memo of settlement. Okay. The counsel for the appellant and respond number 1 and 4. 1 and 4 shall submit the synopsis if any before next hearing date. List on ಇದು ಅಲ್ಲ ನೀವು ಮೆಮೊ ಫೈಲ್ ಇದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ ಅಷ್ಟೇ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡೋದು ಅಷ್ಟೇ. ಮುಂದೆ ಹಾಕಿದಾಗೆ ಮುಂದೆ ವೆಕೇಶನ್ ಬರುತ್ತಲ್ಲ. ಎನಿ ಅರ್ಲಿಯರ್ ಡೇಟ್ ಆಫ್ 11th. I'll say right, but we cannot for judgment she is not required. We have to pronounce the name. Correct. 11th ಹಾಗಾದ್ರೆ ನೀವು ಕೊಡಿ ಇನ್ನು ಇದೆ ಅಂತ ಈ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕಿ. Friday. Friday. By that time, if you want to file memo, synopsis, you file it. Otherwise, proceed. ಬಿಟ್ಟು Yes. ಬೆಳಗ್ಗೆ ಸೈನ್ ಮಾಡಿದಾರಲ್ಲ, they have already signed. See, only effort is that it should be resolved and party should live happily ultimately. Okay.